like to call tonight's council meeting to order for October 23rd. At this point, we're going to do the roll call and the pledge, and then we'll proceed. Mr. Duham, if you would.
Councilor Jennings.
Here.
Councilor Kamani.
Here.
Councilor Duham, aye. Councilor Winterton.
Here.
Councilor Ross.
Here.
Councilor Levesque.
Here.
Councilor Orr.
Here.
Councilor Lazat.
Here.
Chairman Sullivan.
Here. All right, thank you. Would you please join me in the pledge? I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you very much. Okay, the first item on our agenda is a public hearing on a personal issue according to the town charter of, which is 4.6A. So with that, we will proceed. Before we begin, it is regarding a disciplinary action from the town administrator to a department head, and according to 4.6A, we are holding this hearing tonight, which has been requested to be held in public. So we're following our understanding of 4.6A on the town charter, which is titled disciplinary action. Before we proceed, we did receive a legal notice from, I guess I should say, it's between the town planner, Joanne Duffy, who's the department head, who received a disciplinary action from the town administrator. In front of us, they both have their legal counsel, which is their right. We did receive a notice from Attorney Douglas, who is representing Mrs. Duffy, regarding the process that the council is holding. So what we're going to do is address those two issues regarding whether we are holding this hearing properly, and we did receive that notice, and I'm going to reference that 1 second. And I have the letter, which is dated October 17th. PL of the proposed discipline of Joanne Duffy. There's two items the council wants to address regarding that. The first item is regarding 4.6A, as I keep referring to, states that once the hearing should be scheduled within 2 regular scheduled meetings of the council once the council received the notice of the request to have a hearing. And they're asking that we waive that notice because we didn't adhere to the process. And at this point, we'd like to have a motion stating that the council did meet that requirement, and if we moved and seconded, then we can discuss why I'm asking for that motion. Council?
Chair, I'll offer up that motion. I'll make a motion that we accept the chairman's assertion that he was notified of the hearing on September 26, 2013, in accordance with 4.6A of the town charter by roll call vote.
I'll second that, Mr. Chairman.
Okay. So what happened is the letter that I received, or reference to that letter, was dated September 23rd, which was the Monday before the council meeting, which was scheduled September 25th. First time I was aware of a request for a public hearing from Mrs. Duffy was via an email, and I have a copy of the letter. I have the statement from the email, which was dated Thursday, September 26th at 11:54 a.m. The letter that was actually sent, dated the 23rd, is here, and I actually did not receive it until the other day, which is clearly after the council meeting, and it's been unopened. So according to my understanding, The first time I received that was on the 26th, and since it was not mentioned, so it's up to the council to decide on whether we believe we are meeting the requirement under 4.6A. Any discussion? Council, anything else? Okay. All right, so, Mr. Luzon, could you please restate that motion for us?
Actually, could I have the recorder?
Yes, please, would you please do that,
Yeah.
Katie?
Katie?
I have a motion to accept the chairman's assertion that he was notified of the hearing on September 26, 2013, in accordance with the requirements under 4.6A of the charter.
And I'll leave those two documents, the open letter, as well as the date of the email.
Okay. Sure.
Yes.
I requested that be under roll call vote.
All right, please, we need a roll call on that motion. Mr. Duhane?
Council Ward.
Aye.
Councilor Jennings.
Aye.
Council Kaman.
Aye.
Council Duham, aye. Council Winterton.
Aye.
Councilor Ross.
Aye.
Councilor Levesque.
Aye.
Councilor Lazat.
Aye.
Chairman Sullivan.
Aye. Just to make the note that the letter that we received, that I referenced, that first point is here. It's a 4-page document, so I haven't referenced all of it, but I guess this would certainly be public information anyways. All right. The second item that there was question on, whether we were following our rules, was in addition to the scheduling, there's a concern about the town's violation of the town council rule procedure 8, and we do have for the council, which we're aware of, the procedures, which states, and I'll read that. Well, actually, it says right here in the letter. According to Rule 8B, the agenda for the regular council meeting shall be posted by the close of business on Wednesday prior to the regular council meeting. However, in the case of October 23rd, meeting agenda, the Administrator Shankle did not post the agenda until Thursday 17th. So the question is, did we adhere to the proper posting of our rules? So the question is, do we? So I need a motion to confirm that the council is in compliance with its own rules. Mr. Jennings.
I want to make a motion that Rule 8 is inapplicable in this type of meeting. It's not a common occurrence.
I'll second that.
Okay.
Chair, could I request?
Yes, I'm going to ask a question. We'll do a roll call, sir,
Yeah.
as requested. Any discussion on that? Yes, Council Winterton.
Clearly, this meeting is scheduled more as a convenience to the volunteer members of the town council rather than as a portion of the town council meeting. And that's why it is today. It is my belief that legally, we would only have to post this 24 hours before. Thank you.
All right, very good. Any other discussion on that matter? Seeing none, as requested, would you please do a roll call for us, Councilor Duhane?
Councilor Levesque.
Aye.
Councilor Ward.
Aye.
Councilor Jennings.
Aye.
Councilor Kaman.
Aye.
Councilor Duham, aye. Councilor Winterton.
Aye.
Councilor Ross.
Aye.
Councilor Levesque.
Aye.
Chairman Sullivan.
Aye. So with that, we're going to proceed into the hearing. Prior to this hearing, the council met to clarify the process that we'll be following for this hearing. We do have our own legal counsel, which is Mr. Sean Tangway, who's here to advise the council. And in the meeting prior, in the information on how we would proceed was sent out to both legal counsels for the administrator as well as for the department head. And that would require, and they all have a copy of that, which indicates there will be a brief statement by the town planner's legal counsel for 5 minutes. Then there will be a brief statement from the administrator's legal counsel. After that, there would be presentation of testimony and evidence from the town planner. And following that, there's some guidelines within each, whereas the witnesses shall come up forward to be questioned, and the council will have opportunities to ask questions as well. Once that's completed, we'll move on to the second part, which is the The town administrators, the legal counsel shall come up and follow the same procedure, asking witnesses and presenting information, whereas the counsel can then ask questions. Once that is done, there will be closing statement from the town administrator, legal counsel, and then a 10-minute closing statement from the legal counsel for the town planner. And at that point, after that, the council will move to close the hearing, and then there will be discussion, schedule a public deliberation, whereas the council will decide on the question. And the other information that we received prior, according to our advice from Councilor Tangway, was the list of witnesses and witnesses, as well as the list of exhibits that they'll be discussing. My understanding is the scope of this will fall within the witnesses and as well as the list of documents that are presented. Any other additional information beyond that, I believe the council will not entertain. Okay? So at this point, according to agreed upon procedures, we will ask for Councilor Douglas, Attorney Douglas, forgive me, I get tongue-tied sometimes, to do a 5-minute opening statement. Yes, okay.
If I might just interject.
Questions of,
I just want
please.
to address the procedure just quickly. The town administrator has determined that he wishes to make the opening statement. I assume that's not an issue for the council. And the town administrator also is going to present his own direct testimony rather than me doing direct testimony, just so you're aware. That's what he wanted to proceed, and I assume you wouldn't have any objection, or would I assume council have objection to that?
Consideration from you first?
I have no objection.
Okay. So with that, as the chairman and the hearing officer, we agree to those terms since you both do. Okay? So with that, Attorney Douglas, if you would. And if you would, since it's being videotaped, if you just use a microphone so it will be recorded, so we appreciate that.
Thank you, councilors. I want to thank you for taking this opportunity to hear our appeal today. I first would like to address just briefly the motion to dismiss. I feel that I need to state for the record that the way my motion to dismiss was characterized was not the way that I intended it to be. So I just need to state that for the record. Moving forward on the merits, today you are going to hear a story about a woman who has served this town well for nearly 20 years. Her job, pursuant to her job description, is to provide legal guidance and support to the planning board. This woman, at the request of a planning board member, researched the current sign ordinance for the town of Hooksett, its implementation, and its enforcement. And this woman presented it and possible alternatives to a planning board member, a single planning board member, in the fashion that she had always been taught to do and in which she had done for years. This woman then received an ambiguous email from the town administrator, who said he was unsure about the appropriateness of her communication with that single planning board member. But, he suggested, in any case, she should use the documents that were utilized, that were the subject of that communication with the planning board member, and continue to research them and report back to him. The woman did this, and then without any clear direction, much less prohibition, from the town administrator, her supervisor, she met with the planning board member again. She was not told that she was not allowed to meet with that planning board member again. Somehow, Nevertheless, after this, the town administrator divined that he had given her a clear instruction not to meet with that planning board member. And he wrote her up for insubordination. At this, Miss Duffy contemplated what to do. And what she decided to do was to explain herself and to apologize for the perceived insubordination, and to reiterate again and again that she understood that Dr. Shankle was her supervisor and that she needed to follow his directions, but that she did not intend to be insubordinate. This wasn't sufficient for Dr. Shankle, this apology letter. He met with Joanne Duffy again, and this time he lambasted her, quite frankly, criticized her upbringing, and threatened to discharge her unless she accepted the following disciplinary action: a training every single day for a year, involving an hour-long meeting with him each day, wherein he could devise any project or topic of study at his whim for her to accomplish. And if she was late once for one of these meetings, which were to occur throughout an entire year, every single day, she could be discharged. The woman, Joanne Duffy, believing that it was this meeting with the planning board member that was the real issue, and that was the source of this conflict with her town administrator, quite reasonably offered to submit to training under the right to know law, and even offered to prepare a training herself after she was properly and additionally trained on the right to know law for the town and for other committees and boards and for other interested citizenry herself. This suggestion of training in what should have been in the substantive issue was again not sufficient for Dr. Shankle. At the close of the hearing today, you will see that there is not actually just cause to discipline Joanne Duffy. And this year-long training that Dr. Shankle has proposed, every day for an hour, not a minute late or subject to termination, after nearly 20 years of quality service to this town. This disciplinary action is not reasonable. Thank you.
Thank you very much. And now we'll hear from Dr. Shea.
I would like to open by making 3 points. First, my goal today is to present to you the information I had available when I wrote the letter to Joanne on September 20th. Basically, I will be trying to help you understand why I made the decision I did, and I hope you will agree. That is, I believe then, and I believe now, that Joanne was part of a small group of people tasked by the planning board to work on the sign ordinance on their behalf. I further believe then and believe now that this group was therefore a public body as envisioned by RSA 91A, and I believe that as a department head for the town of Hooksett, she should have understood this and complied with the law. I would like you to keep something in mind as you listen to the testimony today and as we go through the exhibits. The letter that I sent to Joanne on September 20th regarding her discipline seems to have led
to the development of an alternate reality. If you pay close attention to what happened before and after that date, September 20th, including today's testimony being after that date, I think you will see what I mean. Second, regarding whether the disciplinary action I am suggesting is reasonable considering the offense, as you have seen in my letter, I consider Joanne's actions to have demonstrated not only a lack of understanding of the right to know law, but also basic management techniques. I will point some of these out as I go through the case later in detail. All I am suggesting is between 150 and 180 hours of training. This is roughly equivalent to the time a student would be expected to put into a one-semester, 3-credit course, if you include study time. So, I am going to try to see that she gets training in the basics of public management, including teamwork, chain of command, etc., communications, legal issues, and more in a one-semester course. I know it will be difficult, but I think we can cover the basics. Third, I would encourage you to remember that this is about the public's right to know what their government is doing and to see public policies being developed. I suspect we will see attempts to nitpick the law or shoot at loopholes, but I think we should expect more than that from our town staff. I want to conclude by repeating verbatim something I said above. I believe then, and I believe now, that Joanne was part of a small group of people tasked by the planning board to work on the sign ordinance on their behalf. I further believe then and believe now that this group was therefore a public body as envisioned by RSA 91A, and I believe that as a department head for the town of Hooksett, she should have understood this and complied with the law.
Thank you both. According to our schedule, agreed upon schedule, the next item would be presentation of testimony and evidence by our town planner. So, Attorney Douglas.
Thank you. I have a number of exhibits that I'd like the counselors to review as I take Joanne through her testimony. Might I distribute those to you now?
Please.
Can you just give me a second? I have to go too long. Do you have an inventory?
I provided in the list.
Oh, okay. Just on behalf of the town administrator, I would just, Stephen Buckley on behalf of the town administrator, I would just point out that in the exhibit packages, an affidavit from planning board member Richard Marshall, and I did tell Attorney Douglas beforehand that I'm going to object to the attempt to submit evidence other than through live witnesses. I talked to Mr. Marshall myself, and he said he couldn't be here tonight. I just don't think it's appropriate to submit an affidavit. So I'm certainly agreeable to have the packet submitted, but I am going to ask to strike from the packet at an appropriate time the affidavit Richard Marshall, because that's, you know, I can't confront and cross-examine a piece of paper, and that's what's being submitted. There are other exhibits in here which I think are irrelevant, but I don't think we need to spend a lot of time on that right now. I just want to focus on the affidavit of planning board member Richard Marshall.
Might I just respond to that objection?
Please do it.
The rules of evidence do not apply to this hearing as we were advised by Attorney Tanguy. What Attorney Buckley is objecting to is a hearsay rule in that he is not able to cross-examine Richard Marshall. And I have two points to make there. First, we were given notice of this hearing as of midday, October 17th. We had 4 days in which to call our witnesses. Mr. Marshall was prepared to testify for Ms. Duffy, obviously. He completed an affidavit on her behalf, but he was unavailable to testify for her today. Secondly, Dr. Shankle has put the interests of apparently a select few planning board members at issue. And in order to adequately defend herself, Mr. Marshall's testimony should be heard.
Based on the request, whether we shall consider the affidavit from Mr. Marshall, I need to consult. I would like to hold off ruling on that until we get to that juncture where you had planned to present or plan to request information from Mr. Marshall. So it may be something that, so at that point, we're going to hold off on ruling on whether we'll take the affidavit information from Mr. Marshall.
To make it easier for the chair, again, I would agree that the document could stay in the packet that Attorney Douglas is going to offer as her exhibits. I'm not going to object for any of her other exhibits. All I'm saying is, at such times you go into deliberation, I am going to move to strike it, and we can do that at the end of the hearing. And that's a lot easier to handle it rather than having her go drag it all out of the papers right now.
That sounds fine to me. Okay. And I didn't have my mic on, so I apologize, so.
Could you tell us a little bit about your history working with the town of Hooksett?
Mr. Chairman, I think the witness should be sworn in.
If that's council, there's a request to swear in the witnesses. Shall we do that?
I think council could, she could do the matter.
So if,
Is there objection by council to being sworn in?
No.
okay, so with that, I believe we should swear in, I don't have the particular wording that we should use. We do have the oath of office that we give to someone becoming a counselor.
Mr. Chairman, I think Attorney Douglas can handle the swearing, and she probably does it frequently in the legal proceedings.
I think both council can do that for both sides.
Okay, so if for each witness, please swear your witness in. Thank you.
Joanne, you promise to tell the truth, the whole truth, and nothing but the truth?
I do.
Joanne, could you tell us about your history working for the town of Hooksett?
One more thing, Mr. Chairman. Do you think it's appropriate to have the witness at the witness table? That's one of the reasons when we set it up.
And just help.
Forgive us, we want to make sure we do this correct. For the witnesses, whether it be Mrs. Duffy or the administrator, I think they can say that, but for the other witnesses, I certainly would want them to come up and take the appropriate seat.
Thank you, Mr.
Does
Chairman.
that sound all right?
Sure.
I do have a question from council, so I may change. Yes, Council Lozart.
Since we're videoing and recording, we just got to make sure that the microphone is, so we get all the testimony on the record.
So perhaps that may be advised that you sit there so the attorneys have their own mic, and then the person responding can speak on the mics without sharing. So I think for video and sound effects, I think that may be best. So thank you for that. I do have another question from Council. Yes?
Now we can turn the microphones a little louder.
Okay.
I don't know what you said.
All right, so thank you for that, just so everyone can clearly hear and we don't miss all the statements, so. Okay, thank you for that. And I'm off? No, I'm not. Okay, so Councilor Douglas, please.
Third time's a charm. Joanne, could you tell us a bit about your history working for the town of Hooksett?
Is this working? Yeah. I was first hired by the town of Hooksett July 1st. Before I talk, I just want to apologize. My asthma is really flared up and my throat is all clogged up and I keep coughing, so please excuse that. I was hired by the town July 1st, 1993 as a land use clerk. I received several promotions while employed by the town. July 1st of this year was 20 years. Some of my titles included administrative assistant, assistant planner, planning coordinator, and, town planner. I was promoted to the position of town planner in February of 2007.
Is there any document, Joanne, that outlines your duties as a town planner?
My job description would outline my duties.
And what do you claim are your duties as a town planner?
My basic duties would be to staff, first of all, I am in charge of the community development department, so I supervise the employees in that department. Our department staffs both the planning board and the zoning board of adjustment. I personally have lots to do with the business community and meeting with the business owners, both future owners and current owners, on issues that they may have or projects that they're looking to develop. Our department is also helps the planning board update the master plan, all the zoning ordinances each year, and the development regulations. That's the basic duties.
Do you ever provide technical assistance or advice as to the laws and regulations surrounding the duties of the planning board?
Yes, on a regular daily basis.
Is it your function to support the planning board?
Yes, both myself and the assistant town planner attend the planning board meetings, and we provide all of the, pertinent information that they need, the applications and things like that.
I'd just like to direct the councilor's attention to exhibit at page P40, which is Joanne Duffy's job description, town planner's job description. Joanne, have you received any positive feedback regarding your performance as a town planner?
Yes, I receive positive feedback fairly regularly from the developers and the applicants that I work with. I've always tried to be sort of someone who can bring people together. A lot of times when applicants go before the planning board, there's some animosity from both sides on various issues because they don't agree, and I usually act as the middleman and try to bring the process together. I myself was a planning board member for 18 years. I was elected planning board to the town of Goffstown, so I kind of know both sides of how it all works.
Have you received any letters complimenting you for your work?
Yes, I have.
Do you remember who sent those letters?
More recently, I received a letter from Stebbins Commercial Realty, who has done various projects in the town. Merchants Motors, I've been working with them now for the past 20 years. And I've also received some letters from, one letter from the, I don't know the exact name, but it's the organization that runs Roby's store, due to some legislation that I testified on their behalf for their tax issue, as well as the library.
I'd like to direct councilors' attention to the letters that appear at pages 43 through 50 in the exhibit packet. Did the Hooksett Planning Board in recent proposed the idea of forming a sign committee.
Yes, they talked about it as a result of the Bass Pro project because they had to go before the zoning board for many variances for the size of their signs. And one of our planning board members, Mr. Walsh, attended that zoning board meeting and came back to the planning board and got them stirred up, to say, we really should be looking at our zoning ordinance and making some changes to the sign ordinance. So that's where it all started, and that happened at the August 5th planning board meeting.
Was it a unanimous decision of the planning board to form a subcommittee, sign
Yes.
subcommittee? Was there a small group of people tasked by the planning board to work on the sign ordinance on your behalf? Or did a small group of people task you with working on the sign ordinance on their behalf?
No, what actually happened was Tom Walsh had said that he would get back to me and we would get together and talk about it, and he got busy, and at the next planning board meeting, which was August 19th, he brought it up again, and the board said, yes, let's get going with this. And so Tom and Mr. Marshall decided that they would they volunteered to participate.
Who is Tom? What role does he play on the planning board?
Tom is a regular member of the planning board.
Okay. And Mr. Marshall?
Mr. Marshall is the vice chairman.
Okay. Were you aware of any hidden agenda that either of these gentlemen had in creating a sign committee or addressing the sign ordinance?
No, I wouldn't call it a hidden agenda. The only thing that they were concerned about, or the biggest issue, I should say, that they were concerned about was the fact that many businesses were coming before the planning board for waivers, and we were trying to find a way to make the sign ordinance more acceptable to the business community and try and cut down on the number of waivers that would be required.
What did the planning board ask you to do in relation to the sign committee?
At the August 19th meeting, when Mr. Marshall and Mr. Walsh, sorry, I'm not used to calling them by their last names, when they volunteered to serve on the subcommittee, they said that there was a discussion that Mr. Marshall actually brought up, and he said, what if we meet with staff first and try and organize something, and then we'll bring it to the sign committee when the sign committee is formed. At that time, there was no sign committee. And so the planning board agreed, although they never took an official vote, they agreed by consensus. And they said to the staff, at the end of the meeting, we'll get together. And in fact, Leo Lassard was there, and Leo volunteered as well. And they said, let's get together at the end of the meeting and come up with a date for that meeting with the staff. And that's what we did at the end of that meeting. We came up with a date of, my glasses, I have a calendar here, August 28th. And we met with Mr. Marshall, Carolyn from my office, Matt LaVoy, who is the building inspector, code enforcement officer, and myself and Mr. Lassard, and Tom was not able to make it.
Was it unusual for you to meet with Mr. Marshall and your staff, Carolyn and Matt LaVoy and Leo Lassard? What is Leo Lassard's title?
Leo is the director of the DPW department.
Was it unusual for you to meet with a single planning board member in advance of the formation of the committee like that?
No, regularly, yearly actually, we come up with zoning changes for the town planning board to assess, review, decide whether they want to go forward with it. We have several workshop meetings for that purpose. And we have often met with the chairman or the vice chairman or who's ever interested. John Gravel, the former chairman of the board, would often come in and we would sit down and talk with them about things.
Is there any record of the planning board asking you to facilitate this meeting?
Yes, it's in their minutes, and it's also on the video that's on the town's website.
I'd like to direct the councilor's attention to the August 19th meeting minutes found at page 63 in the exhibit packet. So what did you discuss at this, forgive me, was Dr. Shankle at the August 19th meeting?
Planning board meeting?
Yes.
I don't believe he was there. I'm not positive, but I don't believe he was there.
What did you discuss at the August 28th meeting with Mr. Marshall, Carolyn Cronin, your assistant, Matt Lavoy, Code Enforcement Officer, and Leo Lassard, Director of Public Works?
Carolyn provided the current, we have 3 different sign ordinances, Article 10A, 20, and 20A. And Carolyn provided copies of all 3 to the staff and Mr. Marshall. And we talked about how awkward it is to have 3 ordinances and the possibility of merging them into one. We talked about what the problem areas were. They seemed to be the building signs and the temporary signs, including the banners. We talked about how we can do things better, and should we tackle the size of the sign the way it's faced now in the performance zone. The further back you are, you can have a larger sign. However, it's maxed out at 25 square feet. And we just kind of threw everything out there. Mr. Marshall's been a member of the planning board for the past 41 years, so he's seen a lot in this town, and he was helpful as far as giving the historical perspective of what they've done in the past. So after that, Carolyn came up with a red line version of what we were coming up with as we saw problem sections of the ordinance. She also did a lot of research on what other towns do with their signs, not just in New Hampshire, but throughout the country. And she provided information from the American Planning Association, et cetera, and distributed this information so we could all read it. And there was a really helpful booklet on how to form a sign committee, which we gave to everyone to read.
Did Carolyn disseminate that red line version and this informational material electronically after the meeting?
She did. She put together the red line version after the meeting and then distributed it to everyone, including Mr. Walsh.
For the councilor's reference, that email from Carolyn Cronin can be found on page 64 of the exhibit packet. What was your intent? What were you planning to do with the information that was generated at this meeting?
Well, once the sign committee was formed by the planning board, we were hoping that we could give this to them as just for informational purposes, so that when they got started on working on the sign ordinance, that it would be helpful information for them to use. We weren't doing anything other than that.
Did you hear from Dr. Shankle about this meeting?
We had 2 meetings with Mr. Marshall. The second one wasn't an actual meeting, but the first meeting we had with Mr. Marshall was on the 28th, as I had said. And the next, I believe it was the next day, I was on vacation. It was the weekend before Labor Day, and I had taken that Thursday and Friday off for vacation days. And I received an email. I get my emails through my phone, so I received an email from Dr. Shankle that said that he didn't feel that, well, first he said that he didn't realize that a planning board member would be attending this meeting, and he thought it would only be staff, and that that he didn't think he wasn't sure if it was appropriate, and that once the sign committee meets, that I would have to explain to them what had occurred. And
so is it your understanding that Dr. Shankle understood that the sign committee hadn't actually met yet?
Yes, that's what he said in his letter. Once the sign committee met, then I have it here. I can read exact language. I was under the impression that the meeting the other morning was for staff and did not realize that a member of the planning board would be there. I am not sure that was appropriate, and it should be disclosed at your first meeting with the committee. And then he said other things about variances and things like that.
Continue, for the counselor's reference, this email that Ms. Duffy is reading is at page 97 of the exhibit packet. And could you continue to read that email, Joanne?
I also understand from Leo that some type of draft ordinance was put together to present to the committee. I think it would be interesting for someone to go through the waivers and variances for signs that have been granted over the last 2 years and see if the proposed ordinance would have made the waiver/variance unnecessary.
Did you interpret this second statement as an objection to the draft ordinance?
No.
And did you interpret this statement as Dr. Shankle trying to determine whether or not waivers/variances could be avoided by this new ordinance?
I think that the goal of the planning board ultimately, with the sign committee doing it, would be to propose a new ordinance that cut down on the number of waivers and signs, if that's what you mean.
Was this not Mr. Marshall's concern as well?
Correct. It was the entire board's concern.
Did you think you were doing anything in violation of any rule or law by having this meeting with Mr. Marshall?
No, we were just staff meeting with one planning board member. We were not advising the planning board of what we were doing. We would have been advising the sign committee once they were formed.
Did you respond to Dean about this email?
I did. I wrote back to him and I explained that the planning board had discussed this on the 19th and that they had asked that we do some preliminary work ahead of the sign committee meeting. And I thought it was pretty straightforward. I didn't see any issues with it, and that was the end of it. I was home on vacation for those 2 days.
For the counselor's reference, Joanne's response is at the top of page 97. Did Dr. Shankle respond to your response, your explanation as to what the meeting was all about?
No, I never heard from Dr. Shankle, and I returned, and that following Monday was the holiday. I returned to work on Tuesday the 3rd. I never saw Dr. Shankle, and then the next day was the 4th.
At this point, did Dr. Shankle clearly state to you that you were not to meet with Mr. Marshall anymore?
No, he never said anything. He never answered my email, and I was not at work, so I had no idea. The only thing I knew was that he had said he didn't know if it was appropriate, and once I explained that the planning board, it was the planning board's idea, that he never answered me, so I thought it was fine.
What happened next?
On September 4th, well, actually, on September 3rd, Mr. Marshall called my office and spoke with Carolyn, and he asked her if he could stop by the next day because he received her red line versions, and he had some questions. And so she came in and asked me, and I said, yeah, why don't you tell him to come by at 10 a.m. And so then she asked me if she should invite Leo, and I said, well, if he's available, it's not really a meeting, he was just stopping by. So Carolyn sent Leo an email and said, if you're around, Dick's coming by. If you're not, if you can't make it, no big deal.
Did Leo attend so that you held a meeting where you met with Dick Marshall?
With Dick to go over the concerns that he had. And yes, Leo did attend. And at one point, Matt Lavoie came in just for a few minutes because we had a question for him.
Did Leo ever tell you that he had heard that you shouldn't be having this meeting?
No, Leo sent me an email very, very early that morning. I think it was like 5 something. in the morning, and he said, I think you should invite Dean, or at least tell him about it.
For the council's reference, that email is on page 98 of the exhibit packet. Did you hear anything else from Leo regarding Dr. Shankle's involvement in the meeting?
No, then we were sitting around the table, a small table in my office, and I think the meeting started around 10, and maybe halfway through, Dr. Shankle walked into the room and kind of looked at everybody like this really quickly, and then he turned around and walked out. He didn't say anything, he just walked out.
Did Leo say anything to that?
Leo got nervous and he said, oh, now I'm in trouble. He told me not to meet, and he was, you know, I wouldn't say he was very upset, but he was upset that he was going to be in trouble. And he told us that Dr. Shankle was not in favor of these meetings.
Leo told you for the first time at that point?
Correct.
So what happened after this meeting?
So the meeting was over, and when I went back to my desk, I had received an email from Dr. Shankle that was addressed to both Leo and myself, and it was telling us that he told us not to have these meetings, and it was kind of, you know, he was mad. I don't remember exactly what it said, but he was mad.
So the email is on page P100 of the exhibit packet. Joanne, would it refresh your recollection if you had the email in front of you?
Okay, we need to take just a short break because the minute taker has to switch over. So, you all set? Okay.
So as you all can read this, he said that neither one of us, meaning Leo and myself, are to provide any further staff support to the sign committee, and he wanted to know when we could meet with him the following day.
How does the email begin?
I told both of you that I thought this was inappropriate. Neither one of you are to do anything more on this, nor are you to provide any further staff support to the sign committee until and unless I give you written permission to do so. When are each of you free tomorrow, in parentheses Thursday?
Did Dr. Shankle in fact tell you conclusively that this was inappropriate?
No, as I stated before, he never answered my email the day that I was on vacation, and I had no indication from him that I had done anything wrong, other than he said that it may be inappropriate, and I would have to explain this to the sign committee once they were formed.
Did you meet with Dr. Shankle that Thursday?
I went downstairs at the designated time. I was 5 minutes late because prior to that meeting, I had a chiropractor appointment. And prior to the chiropractor appointment, I had a TRC meeting upstairs. During the TRC meeting, the police chief and the, I don't know his title, Mr. Daigle, captain, pulled me out of the meeting because they needed a map made, and we were going over the specifics of what they were looking for. And I was late for my chiropractor appointment, so therefore I was 5 minutes late coming back to the office. When I got there, Leo was leaving, and Donna was in the main office, and she knocked on Dr. Shankle's outer door, and she handed, and he didn't come out. She went in and came back out with a letter for me.
Would you recognize that letter?
Yeah.
On page 102.
That's the letter.
Could you just read the highlighted portion for us, Joanne?
After your first meeting with staff and non-staff regarding the sign ordinance, I let both you and Leo know that I did not think this was appropriate because it involved non-staff members, but was not open to the general public, although you were working on an issue for which a public committee had been established. Whether or not it was obvious, I think it should say to you, my opposition to your participation was apparently clear. This therefore would seem to be an act of insubordination, which according to the town's personnel plan is punishable by discipline up to and including dismissal.
What did the letter ask you to do in response?
The letter asked me to write back. He was giving us a chance to respond to this letter and explain why we both did what we did, or why we did it.
And what did you do?
He wanted the letter no later than 8:05 on Monday, September 9th. So on, I believe it was Sunday evening, I sent him a letter through email explaining why I had done what I had done, and I apologized for a lack of miscommunication between the two of us, and told him that, you know, I realized that he is my boss and I would respect him and abide by his wishes.
Take a look at Exhibit 102 for me. Oh, sorry, 106 for me, please. Is that the letter that you wrote?
Yes.
How did you close out that letter?
The last paragraph.
Yes.
I hope we can put this matter behind us and that we can continue to work together with fewer misunderstandings in the future.
Did Dr. Shankle respond to this letter?
He called me in, had me come into his office. I don't remember the exact date. I think it was the 9th. I'm almost positive it was the 9th. And he asked if he could meet with me, and I came downstairs. And when I got there, he questioned me for about 40 minutes as to what had happened and why it had happened.
Was there anyone else present for this meeting?
Donna Fitzpatrick was present taking notes.
And did you take notes as well?
I took my little one-page note in shorthand.
Would you take a look at Exhibit 107, please? Are those your notes?
They are, yes.
Okay. Can you read the highlighted portion at the bottom of those notes for me, Joanne?
At the conclusion, I told him I had the utmost respect for him. Horrible handwriting. I would never disrespect my boss. I wasn't raised that way. He said, yes, you were. You were raised in New York. I told him respect was a big thing in my family. I was raised by a tough Irish dad.
And the notes at page 109, beginning page 109, those are Donna Fitzpatrick's notes.
Beginning page 108, those are Donna's notes.
Excuse me, 108. Could I turn your attention to page 111, please? Exhibit 111. Could you read the last line of Donna Fitzpatrick's notes next to J?
It's J. It says, yes, I wasn't raised to disrespect my boss. I am not here to pick a fight, just here to do my job.
What happened after this meeting?
After this meeting, some time went by, and let's see, I just look at my timeline here because I can't remember dates. On September 20th, I received a notice of disciplinary action.
And how long did Dean propose that the council should have, as just a standard exhibit, the disciplinary letter of September 20th? How long did Dr. Shankle propose that you be disciplined?
Dr. Shankle proposed that, first he said that what I had done was grounds for dismissal. However, since I was a long-term employee, that he was offering me a training session for 1 year, 5 days a week, with the exception of holidays or vacation.
And with that training session, what was that training session look like?
Well, it was very open-ended. It was, he said it could be held here or any other place that he chose. It said that the sessions would include topics that he chose. It could be, tests. It could be written material. I could be assigned to read a book and then write a report. It could be online courses. It was very open-ended.
What would happen if you were late to one of these meetings, according to the letter?
It said that if I were late or didn't show for one time, that it would be grounds for dismissal.
Was anyone else who attended the August 28th or September 4th meeting disciplined in any way?
Carolyn and Matt were given a training session. I believe it was for 4 days. It was the week that we had our employee appreciation luncheon. So it was Monday through Thursday, and they were, I think the first day they came down here and they were handed papers from Donna about the right to know law. And then the rest of the week they had to sit at their desks and do, one day was watching a YouTube video training session, I believe it was from the LGC, and exercises like that. And they had to do it for an hour, and it actually disrupted the work day.
Did Dr. Shankle ever offer you this opportunity?
No, I wasn't invited.
Did you ever ask him if you could do a brief 4-hour training on right to know?
During the time period after I had filed for the appeal, Dr. Shankle, through his attorney, had contacted my attorney and made
Well, I'm going to object. We've had discussions on behalf of the town administrator to the extent that we had off-the-record discussions where we tried to reach some middle ground. That's really not an appropriate subject of testimony. It may have resulted in what you would consider a settlement discussion, and I would object to introducing anything along the lines of a proposal that's different than the state of the disciplinary letter, because that's what we're here for tonight, not what we may have discussed that could have avoided this hearing, which didn't happen.
May I respond? The evidence rule that I believe Attorney Buckley is referring to precludes settlement discussions for the purposes of showing liability. In other words, when a plaintiff offers evidence of settlement discussions as a way of saying, see, he offered me money, that means he must have done something wrong, it is excluded. This is entirely distinct. This is the plaintiff saying, I offered to settle, which, if anything, only suggests that maybe she acknowledged that there were some things that she could have learned about the right to know law, which is completely distinct from the purpose of the evidence rule. Secondly, the evidence rules do not apply here. Third, the reasonableness of Dr. Shankle's discipline is at issue here, where Ms. Duffy counter-proposed a very reasonable resolution to this matter. That should be heard.
Again, I just restate, if I'm going to have any kind I make a compromise proposal to a personnel matter or whatever matter, suddenly becomes the subject of a debate in a adjudicatory proceeding, I'm never going to make compromises, and I'm never going to make proposals, and that freezes the opportunity to avoid what we're doing here tonight. So it's inappropriate to discuss a compromise offer, whether made by the town planner or as discussed by the town administrator. And I object to this line of questioning or the evidence.
Let me make a second before I move, please. After discussing it, we should probably try to remain on topic with the extent of the actual discipline, which should be germane to the process. So I would encourage you, I would rule that you should probably stay away from alternates to discipline, because our task here as council is to, based on the merits of the actual agreed discipline action that he provided to her. So if you could maybe stay away from that aspect, we appreciate it.
Thank you, Chairman. Was Leo Lassard disciplined in any way?
I haven't seen anything.
Well, again, we have to be cautious. I would just point out that we have another town employee who has certain rights, as does the town administrator. If a town employee who's not a subject of this hearing is suddenly going to have matters involving his personnel, involving his personnel file, or things in his personnel file, or disciplinary action in his personnel file, that town employee has certain rights to say, wait, I didn't consent to have that heard in open session. Leo Lassard, if he was a subject of this hearing, if he wanted to have a hearing, which he didn't ask for one, he may have requested a hearing, but would have not have said he's going to seek to have it as a public hearing. I think it's inappropriate to go into the discussion of other town employees when they might not consent to having this in public forum.
The relevance of the information, Chairman, is that if Dr. Shankle indeed failed to discipline Leo Lassard, or disciplines him in a much more lenient way, that is probative of him targeting Joanne Duffy without cause. Leo Lassard is a department head, just as Joanne Duffy is. If he was treated differently for the same conduct, that is something that should be considered.
Okay, 1 second, please. I would want to rule, in lack of better words, agree with this line of questioning, because if Mr. Lassard was part of the committee and he was engaged in that, I think it is relevant to find out how his reaction is. So I would try to keep it to how he was involved in this aspect and whether there was equal treatment. So, yes, so.
Thank you.
Sure. But before I proceed, I want to ask the counselor has a question for me. Maybe we can clarify it a little bit more. Go ahead, please.
Chair, just for legal counsel's sake, would the other employee who didn't ask to be in public, would he be afforded that testimony to be given in non-public?
Well, no, the subject matter tonight is Ms. Duffy's disciplinary action, not Mr. Lassard's. I believe the question that was asked by Attorney Douglas was whether or not someone who was working in concert with Ms. Duffy during these meetings or the subcommittee, whether or not that person received the same or equivalent disciplinary action.
Can I just have a moment to ask Mr. Lassard something? I've consulted with Mr. Lassard, and he does not object to this discussion taking place in open session.
Okay, so thank you. You can proceed, Mrs. Douglas.
Was Leo Lassard disciplined?
I didn't see a letter myself, but Leo told me that he was disciplined.
When was he disciplined?
He was disciplined 11 days after I was, and after I had filed my appeal. I believe his discipline was for 6 months of training.
And your discipline was for how long?
1 year.
Has Dr. Shankle ever made statements regarding your age, Joanne Duffy? Joanne?
Yeah.
I'm going to object. I don't know that that's a relevant consideration. We hear about the question of the merits of the discipline, not some other form of alleged discriminatory conduct.
A pretextual motive for discipline.
Again, I would object. We're straying into areas which are not the proper subject of this hearing. We're going to be dealing with anything that possibly could have occurred between Mr. Shankle and Ms. Duffy over the time that they're working together. We'll be here all night. The point is we're trying to get to whether or not the proposed discipline is justified by just cause given the circumstances, not some array of other possible issues the parties might have which are not recorded anywhere in the materials I've seen so far.
I'm going to agree with Mr. Buckley that that issue is outside the scope of this disciplinary hearing.
Thank you, Mr. Chairman. Ms. Duffy, what has happened with the sign committee since your discipline, or since the discipline letter?
Well, the planning board appointed an official sign committee on October 7th. And we had scheduled, there was an organizational meeting held on September 23rd.
Was that organizational meeting publicly noticed?
It was. It was not an official sign committee because no one had been appointed yet, but it was a committee, it was a meeting to find out who would like to serve on the committee.
Who was in charge of publicly noticing that?
My office was. And at the time, we invited members of the zoning board, planning board, and economic development committee. And the meeting was held, and we obtained the names of those people who were interested. And so then we put it on the agenda for the planning board meeting of October 7th to actually appoint a sign committee and to appoint those people. We had a meeting scheduled for October 8th, the following evening at 5:30. And we advertised it as a sign committee meeting. And I can't remember if it was Carolyn or Evelyn on my staff mentioned to me late in the day, about 2:30 in the afternoon, that Dr. Shankle had advised them that he thought that the meeting was not appropriately noticed, and that because the members of the Economic Development Committee actually constituted a quorum of that committee. And so I immediately canceled the meeting, we notified the members, and I then called the municipal association.
Why did you call the municipal association?
I had never heard of that before. When, in all the times that I've notified meetings, if you had the meeting itself scheduled, the people were there for the purpose of being on the sign committee, not economic development. That I had never heard of doing that. The only time we would do it if there was a joint meeting of both committees. So in my case, there would be sometimes a joint committee meeting of zoning board and planning board, and we would advertise it for both. And so I contacted the municipal association.
Is the municipal association the regular resource for you for this kind of information about notice requirements?
We usually contact the municipal association for simple matters because they don't charge us anything. So we're told, you know, if it's something simple. And so I spoke with Attorney Sanderson, who advised me that we should include a note on the agenda that states there may be a quorum of the Economic Development Committee in attendance. And so we reposted for the October 15th meeting with that note, and the meeting of October 8th was canceled.
And then what happened?
So on the morning of October 15th, we were all set to have the meeting. And again, Dr. Shankle contacted one of my staff and told them that he couldn't find on the website, there's a column for all of the agendas by board name, and he couldn't find one on there for economic development. There was one for the sign committee with that notation, but there wasn't an agenda for economic development. So he told me that Attorney Buckley, so I told him what Attorney Sanderson had said, and then he told me that he relayed that information to Attorney Buckley, and Attorney Buckley had disagreed with Attorney Sanderson, and I wrote back to Dr. Shankle and said that I respectfully disagree with Attorney Buckley, and Dr. Shankle said maybe you should contact him yourself because maybe I didn't relay the message properly. So Mr. Walsh happened to be in my office for something else, and I asked him, he was a member now of the sign committee, probably will be the chairman, and I asked him if he would mind sitting down and calling Attorney Buckley with me to figure this all out, and which we did. And we put Attorney Buckley on speakerphone, and my I don't know what you call it, my view was if we advertised it as an economic development committee as well, then other members of the economic development committee could attend, and you know, it looks like they're having a meeting when in fact they were not. But after speaking with Attorney Buckley, he said we should do the prudent thing. I asked him, should we cancel the meeting, and he said, I'm not here to tell you that, you know, that's your business. But his advice was to be prudent, so we did in fact cancel the meeting. I guess I should say one more thing. We do have a meeting scheduled for October 28th, which is a Monday, and I advertised it as a meeting. I put 3 different agendas, one for planning board, one for economic development, and one for sign committee, and they're posted in all 3 places on the website as well as the regular public postings.
2 final questions for you, Ms. Duffy. At any time, did you ever prepare, draft, communicate information to the planning board for any personal or political gain?
No.
At any time, did Dr. Shankle ever mention a concern about catering to businesses in town?
When I was in his office on the 9th, I think it was the 9th, the day that I was in there for 40 minutes, Dr. Shankle seemed to be upset with the fact that Dick Marshall was involved with these preliminary meetings. And he asked me several times if I thought that Mr. Marshall was anti-business, and he said that he was anti-business, and he got mad that I didn't agree with that. And I said, no, I wouldn't describe Mr. Marshall as being anti-business. I would describe him as, sometimes he could be arrogant, he could be outspoken, he speaks his mind, but I would never describe him as being anti-business. And I got the feeling that Dr. Shankle didn't believe that. I've known Mr. Marshall for 20 years, and I know he can be a real he plays hardball, but I've never seen him to be against businesses.
Thank you. I have no further questions for Ms. Duffy.
Okay, thank you. At this point, according to agreed schedule, that it's the legal counsel for Dr. Shankle can question. And then after that, there's an opportunity for Ms. Douglas, to redirect, and then the council will then ask questions. So, Mr. Buckley, I believe, at this point.
Mr. Chairman and members of the council, I first want to hand out our exhibit packet, and then also supply a document that I'm going to ask Ms. Duffy to refer to. Good evening, Ms. Duffy. First, I want to ask you, would you agree that you're a town employee as well as a department head, and that you're subject to the town's personnel plan?
Yes, I would.
I've highlighted page 20 and 21 of the personnel plan. They're tabbed for you. I had some questions about those.
I have highlighted 23 and 25. It's about drug testing.
Looking at page 20 that I've highlighted, you'll agree with me that in the highlighted section of standards of conduct, the town's personnel plan says, and I'll quote, certain behaviors which are clearly prohibited, which are considered by the town, constitute cause for disciplinary action up to and including dismissal. Did I read that correctly?
Yes.
And turning to page 21, about the middle of the page, insubordination, it says acting in insubordinate manner toward any supervisor or in disregard of any directive of the town. And if you go back to the prior page, that could be a grounds for disciplinary action or dismissal. Is that correct?
Correct.
Looking at the exhibit packet that I supplied to the council, I want you to turn, if you could.
I don't have a copy of it.
I gave you one. Looking at page 2, this is an email that was sent by Donna Fitzpatrick. It was actually a forwarding of another email which was sending an attachment to, looks like all the planning board members and yourself. Is that correct at the top?
It looks like it, yes.
And you're indicated as a CC recipient of this email?
Yes.
And you'll agree with me that that email was forwarding a letter that the town council chair had sent to the chairman and members of Hooksett boards and committees, and this is at page 4, a letter dated January 22, 2013.
Yes.
And it was designed to bring to your special attention, as well as boards and committee members, of recent changes to the right to know law.
Correct.
Now, looking at page 5, which is the issue I believe that Dr. Shankle was mostly concerned about, would you agree with me that the definitions of a public body now includes an advisory body? Are you aware of that?
Yes, I am.
Now, I'm looking at the definition of public body on page 5. This is RSA 91-A:1-A, and it's subparagraph Roman 6. And it says public body means any of the following. And I'm going to jump down to subparagraph D, and I'll read as follows. Any legislative body, governing body, board, commission, committee, agency, or authority of any county, town, municipality, municipal corporation, school district, school administrative district, chartered public school, or other public subdivision, or any committee, subcommittee, or subordinate body thereof, or any advisory committee thereto. Did I read that correctly?
You did.
If you could turn to page 11 and 13 of the packet. This was a meeting of the planning board of August 5th, 2013. Page 11 is the starting point, and page 12 is the next page, where the initial discussion took place with regards to developing a sign committee, subcommittee of the planning board. Is that correct?
Correct.
And subsequent to that meeting, the planning board met again, and this is at page 15 of the submitted packet, on August 19, 2013. Do you have page 15 in front of you?
Yes.
Now, one of the things that it says, seems to me, but you tell me otherwise, that based on the prior meeting we just discussed, which was the meeting of August 5th, there had been those who had volunteered, which were indicated as Tom Walsh, Leo Lassard, Carolyn Crone, and Dick Marshall and yourself. Is that correct?
We had volunteered as staff, not to be as members of the committee. So the minutes are not 100% clear on that.
But what is clear is that at least 2 standing members of the planning board had said, we'll sit on this subcommittee.
They had volunteered to be on the subcommittee, correct?
Okay. And then there was a discussion, and Mr. Marshall said about meeting, and he made clear that, apparently this is the case, that he's generally available during the day, and that you and Leo would be available during the day. Did I read that correctly?
Yes.
Now, Mr. Walsh then said nighttime was best for him.
He did, but after the meeting, we all got together and agreed on a date and time.
But you'll agree with me that one of the entries at the end of this meeting, he says, if you could post the daytime meeting, there's a good chance myself or others could attend.
I thought he was referring to the actual sign committee, because when we had this discussion, we were talking about whether the sign committee should meet in the daytime because there were staff members involved, or whether we should have nighttime meetings. And I thought Mr. Walsh was referring to when we actually have a full sign committee. We did decide as a compromise to meet at 5:30.
But it's pretty clear to me, I'm sure to the council, unless I'm mistaken, he's saying there should be a posting that's taking place. And a posting refers to the requirements under the right to know law, isn't that correct?
I don't believe Mr. Walsh was referring to the right to know law, since the sign committee had not yet been appointed.
Turning to page 17 of the submitted records for the town administrator. These are minutes of the Economic Development Committee of Tuesday, August 27, 2013. Is that correct?
Correct.
Now, it's highlighted with the three striped pen marks on the margin. There was a note, which I presume was your comment at the meeting, note colon, the sign committee will meet on Thursday, August 28th at 10 a.m. J. Duffy invited board members to attend. Did I read that correctly?
Yes, and I think that the term sign committee was being used
Ma'am,
very
I didn't ask you
loosely.
to give an explanation, just said,
Please.
did I read it
I have to
correctly?
object that the council needs to allow the witness to answer.
If you try to stay within the confines of the question, if you would, please.
I think the term sign committee was being used very loosely at that time because we kept talking about the sign committee, but the sign committee never actually happened until October 7th. And if I'm guilty of anything, I shouldn't have called it sign committee. I should have called it organizational meeting or whatever. I did that on several occasions when we had other meetings leading up to that October 8th date. And I'll admit to that, I was wrong in calling it sign committee.
Nonetheless, that's what appears in the minutes of the Economic Development Committee. Is that correct?
Correct.
Turning to page 22 of the submitted records, this is an email that you referred to previously by yourself to Dr. Shankle on the 29th of August. Now, I know there's been some discussion about appropriateness, but to be clear, in his email to you, he says, quote, "I'm not sure that that was appropriate and it should be disclosed at your first meeting with the committee." So what Dr. Shankle is saying is, he knew that you had a meeting on August 28th. He knew that Mr. Marshall was there. He knew that you were there. He knew that Leo Lassard was there, and the code enforcement officer was there, as well as Carolyn Cronin. Is that correct? Can you just say
Yes,
this?
yes.
So, my mic keeps going on and off, sorry. So, he's telling you, I saw you had this meeting, and I don't think it's appropriate. Did you not understand the word appropriate or inappropriate?
I did understand the word appropriate, and that's why I wrote back to him as soon as I saw this email.
Well, I want to ask you about your reply, because I think it's important to the context here. In your reply, you said, the draft, apparently the draft that you were working on with Mr. Marshall on the changes to the sign ordinances, combining the three ordinances into one or changing content thereof, you said the draft is just a starting point, so we can move forward from there, rather than spending hours discussing the same thing over and over. And I guess my question to you is this. It sounds like you would really rather have this meeting without having to listen to a lot of people talking about what they want. You just want to have a meeting with your group, Mr. Marshall and others, and develop the draft outside the view of the public, so you don't have to spend hours and hours discussing the same thing over and over again. That seems to be what you're saying to Mr. Shankle.
That was not my intention at all. What I meant was that there were members that were interested in serving on this, that were members of the Economic Development Committee, and they really are not familiar at all with our sign ordinance like the planning board members are. And we would have been rehashing a lot of things that they wouldn't have understood. I would also like to add that had I had a conversation with Dr. Shankle, maybe all of this could have been resolved, because as you all know, you can take different things from emails, but he has not spoken to me since September 4th, except for at a department head meeting.
All right. You're the head of the department, the Community Development Department. Your supervisor is telling you something is inappropriate. And your position is that if he doesn't reply to your email, that you've gotten the all clear from your supervisor, that you don't have to take any further action to make sure your conduct is fully in compliance with the right to know law?
when he said he was not sure that it was appropriate and should be disclosed, I didn't take that to mean that we shouldn't continue to work on the project as the planning board had given the okay to. And I didn't see anything wrong with it because there was no committee at the time, and we were not violating the right to know law because there was no committee.
Well, let's be clear. You agreed with me before that the new statute that the town council chair brought to your attention through a letter he wrote to all the boards in January of 2013, that new right to know law carries with it a new definition of advisory committee. And it's very clear, it's a subcommittee or any committee advising a subcommittee.
However,
And so are you saying that this group that you had together was not in fact advising the planning board ultimately on the content of the proposed sign ordinance changes?
what I'm saying is that the advisory committee was the subcommittee, not my staff. And it says in the law that the advisory committee is appointed by the appointing authority, which is the planning board. The planning board appoints the sign committee, and they are the advisory committee. My staff and Mr. Marshall is not the advisory committee.
But only by virtue of the fact that Mr. Walsh is there, your position is as long as only one planning board member is present, that's still not a subcommittee of the planning board?
There was no quorum of the planning board present. It takes 4 people to make a quorum of our planning board, and there would have been 2 members present. However, there was just 1 because Mr. Walsh was not able to attend.
Of course, we're not talking about a quorum of the planning board. We're talking about this meeting, this run group of those who are going to revise the sign committee, the sign ordinance, and do it in a way that you won't have to have long hours of discussions. You're just going to be able to quickly do it yourselves with apparently no public input.
As I stated before, emails can be perceived in different ways. I have never had any intention of keeping the public out of this process.
All right, well, moving on to page 24, I want to talk to you about the communications you had with Mrs. Lassard that led up to the next meeting. Again, so we're clear, Mr. Shankle, Dr. Shankle expressed his concern about the meeting you had on August 28th. You said, well, this was something the planning board wanted me to do, and we're trying to save time by not having hours and hours of meetings. And because he didn't reply further to you, you felt you were okay. So then you, as you've testified before, you had this occasion to speak to Dick Marshall, and he said he could come by on the 4th. So you had Carolyn Cronin send an email to Mr. Lassard telling him we're going to meet with Dick Marshall and revise our changes to the sign ordinance.
Objection. Council is just simply restating testimony. There's no question here.
I'll get to it.
And he's misstating it, as a matter of fact.
And I'm sure the council will reflect what is accurate or not. I'm just trying to get to the point of the question. So you're at this point where Carolyn Cronin is about to, is asking Leo Lassard to come to this meeting, and then he sends an email to you saying, quote, I think you should have Dean in this meeting also, or at least invite him. Don't you think that your fellow department head saying to you, I've got a concern that Dean had previously expressed a concern to me about these meetings, he apparently expressed the concerns to Mr. Lassard directly as he expressed them to you about being inappropriate. Didn't that put you on some kind of notice that you had to be careful here and that you had to be bringing Dr. Shankle to foreknowledge about this meeting to take place in your office on September 4th?
No, because Dr. Shankle never said anything to me about not holding a meeting with staff and a planning board member. And the only thing Leo said was that he thought Dean should be invited. And I just didn't think it was necessary. Dean hadn't been included from the start. And the only thing that we were doing was going over the the current sign ordinance. We weren't making any decisions or anything of the sort.
Now, we don't
really have a lot of information in the materials that I have about what took place at the meeting on September 4th that led more likely than not to your discipline. But we do have Mr. Lassard's letter, and this is at page 38, and I want to ask you some about what Mr. Lassard said. Now, for context purposes, Mr. Lassard received a similar letter to you that you had received, saying to you, as he received, I'm really upset, you didn't do something right, I want you to explain yourselves. And he was told to explain himself, and you were told to explain yourself, you did, and this is Mr. Lassard's reply. And I want to ask you about what he says, and to ask you if this is accurate. He says, when I entered the meeting, and this is the...
Objection. How is it that Mr. Marshall's affidavit is inadmissible, but Mr. Lassard's is? Mr. Lassard's statement, when I am not able to cross-examine him.
I'm not asking her whether this is accurate. I'm asking her if his recitation of what took place is accurate.
First of all, we haven't, the council or I haven't cleared whether we would even get to the affidavit regarding Mr. Marshall. In regards to this, since there was questions that you brought forth that we were allowed to bring up Mr. Lassard's, whether he was disciplined. In this case, we're bringing this into because he was also, he received discipline as well. Even though it was different, he did receive discipline. So I believe it's within the scope of this hearing.
Thank you, Mr. Chairman.
So, just the context, as I understand it, is Mr. Lassard is entering your office. You're already in your office on September 4th with Ms. Marshall. It's around 10 o'clock in the morning. I don't know if Carolyn Cronin was there, but he enters and you're both there. Is that an accurate description of what took place?
Yes, Leo, what happened was we were all sitting around the table talking about the edits. And as I stated before, Dr. Shankle walked in, looked around the room quickly at all of us, and said nothing, and immediately walked out. Leo then said he was in trouble, Dr. Shankle didn't want this meeting to occur, and that's when we all became aware of it, and that's when those, Mr. Marshall said, this is the planning board. And
But Ms. Duffy, that's not what Mr. Lassard says. Look what he says. He says, when I entered the meeting and noticed, and when he's referring to you, he's referring to Dr. Shankle, you were not present. I immediately asked if you were notified. Presumably what he said was Dr. Shankle notified of this meeting? Did that or did not happen?
That did happen, but he never said why he wanted to know that until after Dr. Shankle came into the room.
Okay, but he goes on to say that he was told that we were only meeting on changes and it would not be a problem. And then Mr. Lassard said it was stated from both Joanne and Dick that this was okay by the planning board at their prior meeting. Leo said I stated that it doesn't matter. Dean wants to know. At that point, Dick stated Dean does not run or is not in charge of the planning board, and there is a problem. I will discuss it with Dean. And Leo replied, you're all right, but he is in charge of us, and I think you should talk to Dean. Did that take place? Is that what Leo said or heard you or Mr. Marshall say?
I don't remember the exact words. I do remember Leo said that he was going to be in trouble because Dr. Shankle told him not to meet again.
So to be clear, you're not saying this was not said, you're just saying you don't recall these words either by you or Mr. Marshall in reply to Mr. Lassard's inquiry.
Correct. I don't remember that Leo said that that we worked for Dean and all of that. I don't remember Leo saying any of that. I don't really think he did say that. He just said, I'm going to be in trouble. And he looked distressed.
Well, let me ask it this way. If a planning board member said something like that in your presence about your supervisor, and you didn't say anything to at least admonish that planning board member or to make clear to that planning board member that the town administrator runs the town, don't you think that's a form of insubordination on your part?
Mr. Marshall, as I stated before, has been on this planning board for 41 years. He states what he wants to state, and I have no control over what he says. I just sat there and just listened, and we continued with the meeting. It wasn't even a meeting, it was Mr. Marshall stopping by to go over some edits that he thought Carolyn had left out. It wasn't, it probably lasted maybe a half an hour to 45 minutes, and a lot of it was just, you know, not even talking about that. So it wasn't a planned meeting, it was the meeting where Mr. Marshall had called the day before and said, could I stop by?
All right, but again, just the point I'm trying to make is, because it was brought up by your counsel that we're comparing and contrasting the level of discipline that was meted out by Dr. Shankle. And what I'm doing is I'm comparing and contrasting one department head responding to a situation and another department head responding to the same situation in a totally different way. And it appears to me that Mr. Lessard is very concerned that the planning board member is dismissing the role of the town administrator and was concerned about that, whereas you apparently did not say anything to join in that concern, which would seem to be an appropriate thing for you to do as a town department head of the community development department.
Mr. Lessard was concerned about himself getting in trouble. He didn't say anything to Dick about the fact that we work for Dean. He said, we're going to be in trouble because Dean doesn't want us to meet. Because apparently, he said Dean had told him that, and he never said anything to me, so I really didn't know what he was talking about.
Let's turn to your letter that you wrote to Dr. Shankle in reply to his original communication, which in context, I believe the way this proceeded is initially Dr. Shankle sent you a letter, and it's at page 33 of the materials. And I understand that a similar letter was sent to Leo Lessard, where he takes you to task, there's no doubt about it. He says, and so we're clear on this point, he was not immediately disciplining you. He was saying to you as a department head, I have really serious concerns. I'm thinking about a form of discipline. I want you to explain yourself in writing. And that's what this letter was all about. Is that correct?
Correct.
All right. So he waited to decide what he was going to do after he received your reply. And you did reply, and that is found at page 41. Is that correct? Just to turn to page 41?
Correct.
All right. I understand all of the words that are contained in your letter, but one thing that comes out to me, and I just want to see if you agree or disagree, it appears to be the case, which is one of the issues that Dr. Shankle later raises in his notice of disciplinary action.
I need a question. We're talking about future testimony here, about what Dr. Shankle will later raise?
No, I'm just asking, I'm asking her to get a picture from her as to how she was responding to Dr. Shankle's statement that he felt discipline was necessary. So what it appears to be the case is that you're saying in the second paragraph, because the planning board had told you to do something, or the planning board was explaining to you they wanted certain things done, that you felt you had to follow the planning board's directives. Isn't that a fair statement about the second paragraph of your letter to Dr. Shankle?
I explained to Dr. Shankle that the planning board had authorized the two planning board members to meet with the staff. I understand that I don't work for the planning board, I work for Dr. Shankle. However, I staff the planning board, and it was the consensus of that board to go ahead, and I felt that there was nothing wrong with it because we were not holding a meeting, nor did we have a quorum of any board present.
But isn't that one of the very issues that Dr. Shankle raised in his ultimate disciplinary, notice of disciplinary action on September 20th? He felt that you were not taking responsibility for your own actions, and you were placing blame or assigning responsibility to the planning board or others. That was one of his central concerns, and that seems to be the central tenet of your explanation letter, September 6, 2001, 2013, that the planning board told you to do it.
I never placed any blame on the planning board. The only reason I brought that up was to show Dr. Shankle that the planning board had discussed this matter and said that we should go ahead and have this meeting. There wasn't any, it wasn't that there was any malice in that or anything. It was just the planning board agreed that staff should meet with the 2 planning board members.
Just so we're clear about the work of this group, this advisor group of the planning board that did meet on August 28th and September 4th. There is an email which is found starting at page 48 of materials, and then the edited document. What appears to be here is a series of portions of the town zoning ordinance, and they're highlighted in terms of the sections of the zoning ordinance that were the subject of edits and work by yourself, Mr. Marshall, Mr. Lassard, the code enforcement officer, and Carolyn Cronin. And I guess the final point I want to make, I've added up all of the changes to this ordinance, and I've been able to count 28 separate edits to these town zoning ordinances and 2 separate new sections to the zoning ordinance. Now, all of this work was done without public notice, without meetings kept as to how you reach these decisions, and the public had no notice that took place until you later on started having meetings of the sign committee with public notice. Isn't that correct?
The only thing we were doing was brainstorming to give some information to the not yet assigned sign committee so that they could have some material to begin working with. The edits that you see are repetitive because we have 3 different sign ordinances, and these sign ordinances say some of the same things in all 3. So they're repetitive throughout the 3 ordinances. We were not trying to recommend anything. We don't have that authority. And this is no different from every single year when staff provides information exactly as this to the planning board to begin debating what zoning ordinances they would like to change. Staff comes forward with a list of items and a red line version, and we begin from there. And we've done it every single year.
Well, again, but in this instance, this red line versions of these various ordinance changes was a product of a meeting of a member of the planning board who apparently by consensus was agreed to be made part of this advisory group, subcommittee, whatever you want to call it, from the planning board meeting of September 19th, August 19th, 2013, and that's how this came about. This was not just staff, this was members of the planning board who worked on this. Regardless of it's 1 member or 3, that's how it came about. Isn't that correct?
There was not an advisory group or any sort of other group. It was staff and 1 member of the planning board. We were not a group. We were just staff and a member of the planning board. And it's the same thing that we do year after year. And a planning board member certainly can lend a hand and give us some advice on moving forward with the information to provide to the respective board. At this time, it would be the sign committee.
But in hindsight, wouldn't you agree, anytime you have a planning board member participating in any such group to advise the planning board on a matter that's going to come back before the board, whether it's a sign ordinance change or other ordinance change, you would agree with me now without any question. You would post that as a subcommittee and have public notice and minutes kept of such meetings. Wouldn't you agree?
No, I would not agree, because we were not a committee. If we were appointed as the sign committee, then yes, I would agree. But there was no sign committee until October 7th.
No further questions. Thank you.
We would like to take a 5-minute break, and then at that point, Ms. Douglas, excuse me, can do a follow-up. If there's no follow-up, then the council may have some questions. Okay? So we'll be back in 5 minutes. Thank you.
Thank you. Back to you.
Councilor Douglas, if she has any redirect for Mrs. Duffy. Councilor?
Thank you, Mr. Chairman. I do not have any redirect for Ms. Duffy. However, I would at this time like to move for admission of the affidavit of Richard Marshall on grounds that the testimony of Leo, a statement by Leo Lassard containing referencing in detail the substance of the September 4th meeting has been admitted. And fairness requires that Mr. Marshall, the other attendee at that meeting, his affidavit ought similarly be admitted.
Mr. Chairman, members of the council, I don't think it's the same thing, and I was just asking the witness to confirm whether Leo Lassard's description of what took place was what took place, and you heard the testimony. But regardless, Mr. Lassard is here, so we can always call him on direct and ask him if that's his fair and accurate recollection of what took place on that meeting, and is his letter accurate. So if it's necessary, I can call Mr. Lassard.
Let me rule on the request from Councilor Douglas. Okay, please.
Just to be clear, Attorney Douglas, you're asking about the Marshall affidavit, correct?
Yes.
So what we
Well,
were discussing
it's a totally different situation. I mean, I can't run and cross-examine, as she could if Mr. Lassard's testified, Mr. Marshall. I have the same objection. It's still inadmissible because I can't run and cross-examine Mr. Marshall.
At this point, we're going to take that under advisement, so we haven't ruled on that at this point.
Thank you. No redirect.
All right, so thank you. At this point, according to procedures, as I keep referring to, the council may ask questions. So at this point, I'm going to ask if the council has questions for Joanne, and so please keep it to questions for Joanne. So I believe Mrs. Comey has a question for you, Mrs. Duffy.
I have 3 questions. Is that okay if I have 3 questions? Hey, Joanne. Hi. When was the last time that you have actually read the right to know law?
Within the last time I read it, within a few days ago.
Okay. I tried to put the timeline together based on what you had said. On August 19th, the planning board approved the sign committee from the documents here. August 19th, it doesn't basically state that it was an appointed program. So you're saying that October 17th is when the formal committee was created?
October 7th.
October 7th. However, if you could go to your email from you to Dr. Shankle on August 29th, excuse me. It's in this packet. It's on page 22.
So she's looking at the Exhibit 6 from Councilor Buckley.
Yeah, it's page 22, whatever that is.
Okay.
If you could help me with, if August 19th, they talked about having a committee. However, August 29th, you state to Dean the committee was formed as a subcommittee by the planning board. And so that tells me, and please tell me if I'm wrong, that tells me that a committee was formed.
And I guess it should have said the idea of a committee was formed, or what, the wording is not 100% correct. It just meant that the planning board had agreed to form a subcommittee. That's what it meant to say.
Okay. And then one last question, please. You stated earlier that on page 24, I'm going to page 24 now, you stated earlier that the meeting that was held with Mr. Marshall and a few other folks at 10 a.m. in the morning was you were only going to talk about present ordinances? Is that correct? Like you said, well, we're just going to talk about present the 3 present ones at that meeting at 10 o'clock?
Are you talking about the August 28th meeting or the September 4th meeting? This,
The September 4th meeting, it says dated September 3rd to Leo from Carolyn. So I probably should ask Carolyn because I'm not sure. But you had said that your intention was to only talk about the present ordinances.
that was the first meeting that our intention was to talk about the current ordinances and what was wrong with them.
So not this meeting.
At the September 4th meeting, we were only going over the edits, and Carolyn had left out a few things, and Dick wanted to correct that and have her add those things in.
So, okay, so August 28th was the first organizational meeting, and September 4th, the edits had already been created.
The edits to the red line version that you have in your packet was created as a result of the August 28th meeting, and they were then distributed to the staff and Mr. Marshall and Mr. Walsh. And then we met again with Mr. Marshall because he had corrections to be made that Carolyn had left off 2 of the things that we had talked about.
Okay.
And you had said you had another question, or is that
Well,
correct?
well, you know, it's hard to piece all this together, but, so the formal committee, have they met yet?
No, they're planning to meet next Monday, the 28th.
Okay. So there's been no formal committee, so it's established. So there's no minutes.
Correct. We did have that organizational meeting on September 23rd to find out who was interested in serving, and there are minutes of that meeting.
So what makes that meeting different than non-informal?
Because the planning board first wanted to find out who was interested and to bring everybody together and figure out what would work as far as scheduling. And so then those names were brought forward to the October 7th planning board meeting, and then those people were appointed.
And who is on the meeting? I mean, on the committee?
Let me try to remember. There's 5 people from economic development. So Mr. Winterton is on the committee from economic development and planning board. We have Mark. Can you help me? Mark. I can't think of his name. He's on the economic development committee. Mark Sanborn, I believe is his name. We have Leslie Boswack. So there's 3. David Scarpetti and Matt Mercier. And then we have Dick Marshall and Tom Walsh.
Thank you.
You're welcome.
Okay, thank you. Any questions from this side, Councilor Orr?
Is it a common occurrence for a member of any board, particularly, well, let me ask you specifically for you. Is it common for someone on the planning board who happens to be in the building that day to pop in and to ask a question or have a conversation or have any type of communication with your department during the day?
Yes, it happens quite often.
Thank you.
Okay, thank you. Yes, sir. Mr. Duham?
Just one question, just to clarify, Joanne, of course. If Dick was the chair of the planning board, he wouldn't have been able to be on this subcommittee, would he?
He could. There was no restriction on whether you were the chair or the vice chair or whoever. I know that he said he didn't want to chair the sign committee meeting, and he had asked Mr. Walsh if he was interested in doing that.
Okay, thank you, Mr. Jennings. From this side, Mr. Winterton.
Joanne, in your letter on page 41 to Dr. Shankle in the in Dr. Shankle's attorney's packet. It says that the planning board suggested the meeting, but I think tonight that I've heard that the planning board authorized the meeting. Is there a difference?
The planning board authorized the meeting by consensus. They all agreed that there should be a meeting. I did have a discussion with Dr. Shankle about that, and he thought that the planning board should have voted to authorize Mr. Marshall and Mr. Walsh. Unfortunately, they didn't take a vote, but there was consensus, and that's clear on the video. So when they did appoint the subcommittee, you know, it was, I made sure they made a motion. But lots of times boards do take action by consensus.
Okay, thank you. Council Winters, anything else? Anyone else from that? Council Lazat?
Yeah, just one. I noticed the email coming from Caroline Cronin on August 29th refers the subject matter to yesterday's signed committee meeting. I mean, by default, did everyone understand that it was not a signed committee meeting? And
I'm sorry, what page are you referring to, sir?
Page P46 from Ms. Douglas's packet. I guess the question I have is, do you think, excuse me, P64, I'm sorry.
Is that a question?
I'm just wondering, is the subject, she indicates that yesterday's signed committee meeting. Did she believe it was a signed committee meeting?
No, no one believed it was a signed committee meeting, and like I said before, that's what I'm guilty of, calling it a signed committee. It was not yet a committee. I should have called it preliminary signed committee or something like that. But we just all kept referring to it as the signed committee, even though it hadn't yet occurred.
And Chair?
Go ahead. Yes, please.
Ms. Duffy, just out of curiosity, how long did that meeting go on for? The August, I believe it's 28th?
It lasted approximately 2 hours.
And, may I, Chair?
Proceed.
Ms. Duffy, the next question would be, on the edits, I mean, was there a discussion and a debate on each one of these edits in regards to why they would be important or not important, or in terms of, you know, with the vice chair?
The way we worked, it was very informal meeting. It was really a brainstorming session, and we all just threw out there what we felt were the concerns by the business owners as to what they would like to see. Obviously, they want larger signs, and so we tried to create a way of allowing larger signs. However, instead of just saying, let's go with 50 feet, we tried to offer some suggestions about making it proper to the size of the facade of the building. So we worked on that for a while. We brought in the code enforcement officer and asked him several questions about complaints that he has received. And it was really just to brainstorm. And when Carolyn put these edits together, it was just for the basis of a starting point as to where we're having problems with. That's all it was. They could have taken that document and thrown it in the garbage once the sign committee met, and no hard feelings. But it was just to try to get to a point where we were trying to show people what the concerns were from the business community.
All right, thank you.
All right, thank you. Any other questions? Mr. Levesque? I have one question, if I could. So it appears that the first, that August 5th, from my reading of this, was the initial discussion on forming a committee, sign committee, or whatever it may be called. So since August 5th, the committee has not met officially until, has not met yet, is that correct?
Correct.
Okay. The other question I have is under, would be page 22, and I believe it's also in the documents from Ms. Douglas, or Mrs. Douglas, I'm sorry, excuse me.
Yes.
Ms. Douglas. The letter, the email from dated August 29th from Dr. Shankle, where he says, and it's just, I'm just curious, it says, I'm not sure that was appropriate, and it should be disclosed at the first meeting with the committee. So the question I have is, would you have not, I would have asked, well, what does he mean, what was inappropriate about it? Did that ever come to your mind on why is Dr. Shankle saying he believes it's inappropriate, and would you have not asked what he meant by what was inappropriate? I would have done that, but what was your thought process when you, well, appropriate, well, what was appropriate or not?
I think I just typed this up quickly. Like I said, I was at home on vacation with my family. But what I didn't understand was I thought he thought it was inappropriate because we were having some kind of a meeting without being posted. And that's when I explained to him that, the planning board knew about it. It was actually, it was their idea, not mine. And, it was just a staff meeting with one planning board member present.
So you never, look, I don't know if this, he'll tell me to not ask if I can. So you never thought to ask Dr. Shankle what was inappropriate? What did you mean by it was not appropriate?
No, actually, it never occurred to me, I guess because I knew that I hadn't done anything wrong, and it was not a big deal at that time. It really was just, another email answering. It was not to the point where it is now.
Okay, thank you. Is there any other questions? Yes, we do have one from Mr. Councilor Ross for you, Ms. Duffy, Ms.
Yes. It would be, what do you consider the relationship between your position and that of Richard Marshall, the Vice Chairman of the Planning Board?
My relationship?
Yeah, as far as being accountable to him, or just strictly advising him, or does he advise you, or do you have any kind of way you can put that?
No, I am there to advise the planning board, and, they don't always listen to me, but usually they do. And Mr. Marshall, as I said, has been on that planning board for 41 years. I've been working for that planning board, not that board, but the planning board, for over 20 years. When I first started working here, Mr. Marshall was the chairman of that board. He's been chairman several times. I've never had any issues with him. I respect him. I've learned over the years that when you talk to him, you better know what you're talking about, because he will challenge you. And, that's Rob shaking his head. That's, that's Mr. Marshall, and that's our relationship.
Okay, do you feel that it has changed since? Has there anything come to light that causes you to have a different approach now than you did before this episode?
No, we have the same relationship we had before. I have noticed over the years, as Mr. Marshall has grown in age, that he has definitely calmed down from how he used to be 20 years ago. But no, nothing has changed between us.
Okay, yes, thank you, Councilor Ross. Councilor Duham?
One more question.
If you could use your mic, Councilor.
Just one more question. I was just curious, after the August 29th letter from Dean Shankle on page 22 of our attorney's letter in there. I was just curious that, he showed that there was concern. He says, I'm not sure that it was appropriate. I was just curious, after that, why didn't you just CC him about all the material, anything that had to do with the sign ordinance altogether, just to keep him informed that he was? Why didn't you do that? I'm just curious.
I think because, again, this is something I do every year when I put together proposed zoning changes for the planning board. I've been doing it for the past 20 years, even though I haven't held this position, I still did that job. And so it didn't occur to me that there was anything wrong, and I think it was the way he worded it. It wasn't strong language. I'm not sure that was appropriate. And by the way, tell the board or tell the committee once you meet with them. So it didn't strike me as something that was really an issue at all.
Because I was just curious, because when I was reading the planning board minutes that Dean was at the meeting, when they were talking about the committee and mentioned that, he wanted to get active with business letters. So you knew he was interested in this, that he had something that he wanted to stay in with. And I said, I thought that was his key there.
Right, and I think, as you all know, Dr. Shankle used to be a member of the planning board committee, and, we would invite him to things then, but now that he's off the board, I don't normally invite Dr. Shankle to meetings that I have. If I have it with me here, I can show you, just grab it quickly. This is my calendar for a month. I mean, I meet with people all the time, and I don't include Dr. Shankle in any of those meetings unless, he has said he wants to be there or somebody wants Dr. Shankle to attend. But it's not normal for me to invite him to meetings that I have.
Okay, thank you. Yes, we have one from Councilor Rebecca. Councilor?
Joanne, when you were going to have the second meeting, and it was brought up by Mr. Assad that, did you invite Dr. Shankle? And you said no. And was he notified of this? And you said no. What is it? I would think that it would, with the first meeting that he was upset with, I would think that you'd want him to know of it, exactly what was going on. And I have a hard time with that, why you didn't go out of your way to make sure that he understood that you were going to have that second meeting.
I think it's because I didn't know that he was upset with it. And when he used the words, I'm not sure it's appropriate, to me, that was not saying that he was upset. We never had any verbal discussion on this issue at all. As I stated, I was on vacation those 2 days. Monday was a holiday. I came back on Wednesday, never saw or heard from him, and then Tuesday this all erupted. Or, I'm sorry, Wednesday this all erupted.
Well, if my boss tells me something's inappropriate, I would think I'd follow it up, and that's what I'm having a hard time with, why it wasn't followed up after on your part, knowing that it was going to happen again, and that you do everything right, but, that's all I'm having a hard time with. Thank you.
Would you like to respond?
Yeah, I guess it was the way it was worded. I'm not sure if this is appropriate. Didn't say to me he felt it was inappropriate. And, maybe that's a mistake on my part, but there was no verbal discussion. It was just that one line that I had to go by.
Okay, thank you. We have Councilor again, and then I think Councilor Lazat has another question.
I just want to follow up on that. So when you got this email from Dr. Shankle saying that he was not sure that it was appropriate, I'm referring to the one on page 22. Did you refresh yourself? Did you go in and look at the policy? Did you try to kind of confirm that to see if he wasn't sure, to kind of make sure?
I did. I read the right to know law. I realized about the section about advisory committee. And, you know, I came to the conclusion that there was no reason to be concerned because we weren't, you know, breaking any laws. I think Dr. Shankle now, after the fact, now that I know what I know, I think Dr. Shankle thought that we should be doing something in the public eye because this eventually would become a public issue. However, if you read through, the LGC has a rather thick document on the right to know law called the new right to know law, which explains those changes, and it was put together by Attorney Johnston. It says in there that working documents of a staff are just that, working documents, and you don't want to make those public because the public, if they see what you're working on, would then become concerned, thinking that they may one day become the law or the ordinance or whatever. And it was such in a preliminary stage, there was no reason for the public to be involved at that point. It was merely staff trying to be helpful. That's all we were doing. We had no, ideas of leading the town or the committee or whoever any certain way. We were just trying to be helpful. Thank you.
Councilor Lazar?
Chair, I have several questions.
Okay, can I ask just a quick follow-up? You said only staff working documents do not follow under 91A. Is a member of the planning board, in your mind, considered part of the staff?
No, he is not, but he's not a quorum of the board either.
Okay, thank you. Now, Mr. Lazar, thank you.
Yeah, thank you, Chair. Ms. Duffy, one of the things I was reading Dr. Shankle's thing, and I'm just, I'll provide my opinion, but in the first paragraph,
what page are you?
Oh, sorry, page 22 of Attorney Buckley's packet. It's the letter, the initial letter. One of the things that strikes me was that he emphasizes in his first sentence, I was under the impression that the meeting the other morning was for staff and did not realize that a member of the planning board would be there. And then he asserts, I'm not sure that was appropriate and it should be disclosed at the meeting. And when I read 91A's preamble about, which is on page 5, the openness in the conduct of public business is essential to a democratic society, and the purpose of this chapter is to ensure both the greatest possible public access to the actions, discussions, and records of all public bodies, and their accountability to the people. I mean, taking that into consideration, I mean, I think that you believe when you read this that he wasn't concerned that the planning board member was part of it, and that a second meeting would be okay with the planning board?
I didn't know what his concern was because he didn't state it other than saying that he didn't think it was appropriate. He didn't know if it was appropriate having, because he thought it was staff, not Mr. Marshall. I think in my head anyway, at the time, I thought, oh, he must think that we're a committee or something because Mr. Marshall was there. And I knew that that wasn't the fact. I knew that we weren't breaking any laws or anything. So it was just something that it just was, no, this is okay. And then I wrote back trying to explain what had happened at the planning board meeting. And I thought I was all set, to tell you the truth. I really had no idea that this was going to blow up.
Chair?
Follow-up, yes.
You had indicated that it was a 2-hour meeting and that edits had taken place, and Ms. Cronin forwarded an email in the sense of saying the signed committee edits, which I'm not actually looking at that page, but apologize, Chair. The email from Ms. Cronin that I spoke about earlier, which I guess was,
I believe the one you're referring to, Counselor, is in the packet from Attorney Douglas at page P64.
yeah,
So it's the other packet.
yeah. It's on P64. Yes, thank you, sir. So on P64, she writes back to all the people that were in attendance on that and says these are the edits that were made to the sign articles from yesterday, referring to yesterday's sign committee meeting. I guess the question is who? She also states that in a subsequent meeting that Mr. Marshall came and edited those once again to make sure that the edits were correct and such. So was Mr. Marshall making the decision on what was in those sign articles?
No, Carolyn had left out a few things about the size, what size we were including in the document,
Yep.
and he just thought that she had left it out.
So who made the decisions to make the changes?
To make the changes to the second set of documents.
No, on the first edits that she references here on August 29th, it was, you indicated that there was collectively, there was this discussion and deliberation on ideas and so forth in order to figure out how to best enhance the ordinance. Who was the final person who said, okay, yeah, was it Mr. Marshall?
No, Carolyn took notes as we went along, and she went ahead and did the edits on, no one instructed her, go ahead and do a red line. She did that on her own.
Okay, thank you.
All right, very good. I think we have one more question. We have two more questions for you, Joanne. Mr. Winterton?
On that letter that Councilman Lazar just referred to, Mr. Walsh was not copied on that?
I believe Carolyn left him off because he wasn't there, but I sent him that documentation afterwards. I sent it myself.
All right, very good. Ann?
I'm looking at an email, it's on page 26, the packet without the P's. And I'm trying to visualize how this happened. And so you're in your office, you're in the planning board table, conference table, whatever, and you're having a conversation, looking over these ordinances with staff and Mr. Marshall. The email from Dean implies that he walked into the meeting and then walked out. Did he say anything to anybody at that time when he walked into that meeting?
No, he didn't say anything. He just looked around and then turned around quickly and left.
Okay. So he didn't indicate to you at all at that time that he didn't ask a question, what's going on, what's this meeting, what are you discussing? There was no interaction by him at that time?
No, nothing.
Okay. Thank you.
Okay, very good. So with that, that concludes questions for Joanne Duffy. So with that, we would proceed to the next portion, which is 4, where we receive presentation, testimony, and evidence. But 1 second. Oh, yes, we also have, I'm sorry, according to your witness list, you have some other witnesses that you would like to?
There are no more witnesses.
Okay, all right. Thank you for that then. Thank you. So with that, we proceed to presentation of testimony and evidence from the town administrator.
And again, Mr. Chairman, Dr. Shankle is going to present that through his direct presentation. I'm not going to be asking questions directly. He'll just go ahead and present his view of things, which you're going to do over a table. Yeah.
Yes, and you would want to swear him in.
Yeah, I will.
Please.
Dr. Shankle, before you stand down, can you please raise your right hand? Do you solemnly swear the testimony you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Okay, as I said in my opening, what I'm going to look at and what I'm going to go through with you is how I saw what I saw up until the 20th. Now, you've already heard that things may have misnamed, people were misnamed, committees were named not or not, and I don't know what to do with that. I had in front of you, in front of me, when I made my decision, everything up to Exhibit 16, or page 73, which was the posting of the sign ordinance, which actually took place, although the sign meeting, the sign committee meeting took place on September 23rd. It was actually posted prior to that. And I had gone and checked the date of that. I think it was the 12th. And then they got the letter, and the 23rd happened and everything changed. Nobody was anybody anymore. Black became white, and that's what we're going to deal with. So what I'm going to do is go through and show you what I was dealing with when I made the decision on the 20th. Starting with Exhibit 1. And once again, you've already gone through some of these, but I just want to go through because it's what I saw. This was a letter, as Attorney Buckley, I think, said earlier, that this council did. The email went to everybody. You may remember that the reason that you wrote this letter was because of actions that were taken by the planning board, actually against Councilor Winterton. So that was what really started, before he was Councilor Winterton, actually. But that was the basis of this letter. We made it a point of sending him the relevant parts, which included the preamble, the definitions of an advisory committee. And once again, an advisory committee, as I kept saying, a group of people getting together at the behest of a committee of the town, of the planning board, to do work that's going to bring back to them, is an advisory committee. One of the issues that's kept coming up is whether an advisory committee can have a combination of staff members and board members, planning board members in this particular case. When I did call the LGC, and I think that other attorneys may or may not agree, but I guess your attorney could give his opinion when the time comes. But according to the local government center, a committee can be made up of both staff and board members. So there's nothing that precludes that from being a committee. So let's go to Exhibit 2. And once again, that was the start. That's the August 5th meeting. You'll notice, once again, my mindset, when I finally went and looked at this, was sign regulation subcommittee. So to me, that means that this discussion was about a subcommittee of this sign committee. Just flip over that. They talked about it at the end. One thing I will want to mention on page 13, at that point, T. Walsh, L. Lassard, and D. Marshall stated they would be willing to sit on the committee. Right there. Two of those people are planning board members. One of them is a staff person, Leo Lassard. They were all willing to sit on the committee. Nobody said, no, you're going to be a staff person to this. It just went in the minutes. Exhibit 3, meeting of August 19th. Now, there's a few things that I want you to note here. When this starts, once again, sign regulation subcommittee, J. Duffy, says, at your last meeting, you agreed to begin the formation of a sign committee. People who have volunteered are Tom Walsh, Leo Lassard, Carolyn Dronin, Dick Marshall, and myself. Now, I would appreciate it if you write those names down or keep them in your mind, because you will see them over and over again when they're talking about the non-existent sign committee, okay? That is the sign committee that everybody from that moment on considered the sign committee, or a subcommittee thereof. And once again, it was talked about in the third paragraph up from the bottom, if Joanne, Leo, and myself can get together during the day and prepare something in outline form and then call a committee meeting, it would save time and possibly 3 meetings from there. And then Tom Walsh says, if you could post a daytime meeting, there's a good chance myself or others can attend. I don't know what else, there's nothing else in the minutes that could have referred to, in my opinion. The other thing that's important about that particular sentence, though, is that Dick Marshall saw this subcommittee, even if you just talk about it being Joanne, Leo, and myself, he saw that as something that would save the sign committee time. In other words, he was expecting them to do work that otherwise the sign committee would have had to do in public, right? It's an alternate to doing work in public. Let's do it behind closed doors, and then we'll spring this on the sign committee, and I shouldn't say it that way. But the point is that this is work. I understand why they were trying to save people time. But if you're going to do that, you need to admit that you're doing work that was going to be done by the sign committee otherwise. How could it have hurt? One of the things that was said was that they needed to do this pre-work because the Economic Development Committee wouldn't be familiar enough with the sign ordinance to go through it in the same detail they were. Well, one of the things the sign committee should have been planning on doing is educating the people in town, including the members of the Economic Development Committee, including any business that came in, or anybody else interested from the public, on what the ordinance meant and what it was trying to do. To say that it was impossible to bring people up to speed, I have more respect for the public than that. Exhibit 4. Once again, this was discussed. I don't know what else to say except that where it says down under note that's noted there, the sign committee will meet on Thursday, August 28th at 10 a.m. Jay Duffy invited the board members to attend. If the board members were sitting there, they would have to, the Initiative Economic Development Committee, they would have no reason to believe that wasn't a posted meeting of the sign committee. It's what they were told, it's what was said. And you can start saying after the 20th that that's not what was meant, but it's absolutely what was said. And most important, to me I guess, it's what I had in front of me when I needed to make my decision. Go to Exhibit 5. Okay, this is important for a couple reasons. Number one, first, this is page 20. It says it's a sign committee organizational meeting. Words have meanings. Meeting organizer was Joanne Duffy, and look at the names. Leo Lassard, Dick Marshall, Carolyn Cronin, and Tom Walsh. The same names that Joanne Duffy mentioned back on the meeting of August 19th. The same list from Exhibit 3. Let's go to Exhibit 6, page 22. Down at the bottom there, and I'll answer the question that everybody's been asking, why did I just say I was not sure it was appropriate? Well, when I first heard about this, I hadn't been at the meeting on the 19th. And to the best of my recollection, I don't think it was at the meeting on the 19th. So I didn't know at this point that a committee had been assigned by the planning board. This was just a question in my mind of whether it was a good idea, considering all the interest in the community. The fact that I had businesses coming to me to ask me about the signs, if starting this process behind closed doors was really appropriate. The other question I'd like to answer, that's in some of your minds, because it was put there several times, is why didn't I just go and talk to her? Why didn't I go talk to her? Anybody that's in this building knows that the first thing I do in the morning is I go down, I get coffee, and I go, if not from office to office, sometimes I skip some, but between 8 and 9 o'clock in the morning, I walk through. I would say the number of times that I popped in there and said to Carolyn and Evelyn, is Joanne in between 8 and 9 in the morning? Was 0. Okay? I went to talk to her, she wasn't there. That's my practice, it's what I've done since I've been here. And the fact is, after that, the reason I do it in the morning like that, and the same reason that I'm suggesting the training, is once 9 o'clock hits and people start coming out, I get swamped. I mean, unless something comes up and it's something, that I need to deal with, things happen. So I don't always think about it. I get in the morning, I think about what I need to do, try to do it. If I can't get a hold of people, I can't get a hold of people. Nothing I can do about that. And once again, one of the things she said when she was talking about this a few minutes ago, she said that she was concerned when I sent this at the bottom part of page 22, that I might think that this was a sign committee meeting. And the way she tried to allay that concern is to tell me that the committee was formed at the top as a subcommittee of the planning board. So that's why I thought it was. I had no reason not to think that this was either a committee or a subcommittee. And either way, under the right to know law, 91A, it counts. I mean, you can't, once again, start parsing the law. If it was appointed by the planning board, which is what I was told over and over, she said it at least 3 times. It was done by consensus, but it was still done. And she explained very accurately, it's not unusual for committees to do things by consensus. And that's what they did. I'll leave out, I won't mention this P64 one because I didn't have it at the time, but I do think that it's interesting that Carolyn Cronin thought it was yesterday's sign committee meeting too, that you mentioned in the other packet. So I'll just kept that for my own personal interest. Okay, page 24. Once again, you've all talked about what this was. This was for the second meeting. And I will say, and this is another thing I've got to say at this point, had I known that there might be a second meeting, if you go back, I mean, the meeting, my email to her about didn't think it was appropriate, I would have thought if there was going to be a second meeting, I would have heard about it. I will tell you guys right now, if you ever tell me as a council that something I'm doing might not be appropriate, I will not just go do it. I mean, that's not what you do. You find out for sure that you're right. And all it took for me was a call to LGC to find out it was wrong. Okay, Exhibit 8. Page 26. Oh, okay, this is another interesting one because this came up a couple times. She did that. Now, my thing about when I walked in, and I will tell you what happened. I did. Once again, it's my custom. It was probably about 10 o'clock. It looks like I sent this at 10:42. I walk around the building in the morning like that. I was just walking in to talk to her, and to be honest, I was daydreaming or something, wasn't even thinking, and then I got in. And I think she could tell you, and other people could tell you, if I walk into a meeting that somebody's into, 9 times out of 10, I just turn around and walk out. Why would I interrupt their meeting? They're in the middle of a meeting. And until I got back downstairs, it never occurred to me that it might be their second meeting. It just didn't occur to me, or I would have said something then. So I can, I'll plead dumb that I should have thought about that when I was up there. But I walked in and said, ooh, And that's why I just turned around and walked out. It wasn't my meeting, it wasn't my business, so I walked out. And then when I got downstairs, I thought, wait a minute, who was in that meeting? And that's when I sent the email. I also will tell you that once I got downstairs and I thought about it, I think that from my perspective, it would have been inappropriate for me to go up. I never would have gone up and confronted my staff in front of an outsider, in front of the planning board member. So as long as Dick Marshall was there, there's no way I was going to confront him anyway. That's not how you do business. That's not good management practice for me to go in and do that. Exhibit 9. Once again, this is a result of the letter I sent. And once again, her explanation is the planning board is fully aware of this. Basically, we're doing it at their request, right? Their behest. They know we're doing it. We're a subcommittee, and we're meeting again at September 23rd at 5:30, right? The paragraph at the bottom. We're meeting again. All members will be invited. Not all members. It's not that we're going to ask people if they want to be members when they get there. Not is, you know, maybe we're going to have members later, but we don't have a committee yet. What this says is all members will be invited. I have no reason to think that that wasn't true, and I still think it was true. Because she said all members will be invited, and we will present what we have drafted to date to find out what they like and what they dislike, and we'll see at the meeting. That's what they did. Exhibit 10. Well, this was a meeting. Once again, I was learning more. You know, the other thing you need to remember in terms of, you know, me first talking about inappropriate, then me talking about, you know, is this insubordination, and then me talking about this is, you know, a violation of right to know law. My understanding of what was really going on was kind of developing too. I mean, we're talking from, like she said, there was a holiday in there, there's other stuff going on. This wasn't the only thing I was doing during the month of September, okay? So my understanding was evolving too, and that's why I was trying to get a feeling for what was going on. I was gathering information, Donna was helping me, and that's why we were where we were. It's also why I took time before, and we'll get to the September 9th meeting in a minute, but I didn't do anything right away. I like to take my time and think about what I'm doing before I do it, just in case you end up doing this, right? Talking to the public about it. And that was the letter on the 23rd, which is on, well, no, it's not on the 23rd. Letter number 33, I think I don't have it on here, but it was September 5th. Pretty sure. Once again, my concern through this all, I mean, there was some implication that this had something to do with my feelings toward one or more planning board members. My concern is in the second paragraph. Since I have been very actively engaged with the business community on potential changes to the sign ordinance, I felt it was important that staff not appear to be working behind the scenes to craft an ordinance out of the public view. That was my concern, and it's still a concern. I did ask for more detailed information, and don't think I really got that. Go to page, or exhibit 12. I'm not gonna go through Leo's thing. I don't see it as especially important, except just to the degree that you know, everybody sort of knew that I was concerned. Page 41. This is her response. The other one was Leo's response. And okay, back to, I do need to cover one other thing. One of the concerns that was raised earlier was about, and I wasn't going to bring this up obviously, but Leo said it was okay to talk about it. The reason that Leo got 6 months and she got a year. And there were a few issues there. Number one, it's very important to me that Leo understood that he did something wrong and that he wanted to do the right thing. If you see in my letter, let's see what was that in the Exhibit 11. One of the things that 1, 2, 3, 4 paragraphs from the bottom, I said, before I decide on the specific level of discipline, I would like to give you a chance to tell me why you chose to act as you did. I would think that this would involve discussing the town charter, the administrative code, and what you see as your role as part of my administration. It is my administration, of my administration. Okay? What I was trying to do is get a feeling for them as to what they wanted to do. I mean, we've got a lot of things going on here. We've got a lot of things going on with community development. We've got a lot of things going on with everything. And I need to know that the department heads and me are on the same page. And that's what I was asking them. And I felt that Leo was responsive to that. The other difference, and to me this was huge, is that Joanne involved brand new employees of her department in this without making sure, knowing that I was concerned, knowing that I might have thought it was inappropriate, not really sure that it was, I mean, she thought she was sure, but if she's wrong, she's wrong. But why would she include, neither one of those people have been up there 6 months. Why would, I mean, close, but why would she include them in this? Why drag them into this? And also, the other difference between her and Leo is that she hosted it. She's the one that said the second meeting, Leo doesn't even need to be there, so he was not as integral a part of it. So that was really why. I think that the training opportunities for her are more than for him at this point. She also has been here 20 years, as she pointed out. You know, Leo worked in the private sector. He's been here 2 years. You know, so we got things we have to do. You know, people respond, responsibility is responsibility. Okay, so let's go to 14. Number 14. Okay, this is the one that sent out the entire red line draft of the sign ordinance. As Carolyn pointed out in the end of the first paragraph there, it was a combination of her research, Joanne, Leo, and Dick's institutional knowledge that put this together. That was the committee that had been meeting. Tom Walsh was included in that, on that Exhibit 3, but he hadn't been able to make it. But this is the same committee, the same names from the beginning. And I do think that if you look, you know, as you go through that, there are a lot of things. I mean, they clearly went through this ordinance line by line, deciding what to do. And honestly, I think an exercise like that with a 40-year member of the planning board, done in the public, with the TV cameras running, would have been a great boon to the entire town. To not do that in public was a shame. I think Dick Marshall does have a lot to add to those kind of discussions, but I think everybody has a right to see what those additions are. Now we get to the meeting of September 9th. Once again, I've been going through this. You know, the first meeting was really where it came up was right after the August 18th meeting, so we're really talking a 2 to 3 week period here. Been doing other stuff. But I thought I would go to the September 9th meeting, trying to straighten it out. That's why I haven't done anything yet. I want to figure out what's really going on. So come in, page 69. Come in, so Dick Marshall starts and says, in our last meeting, this is once again the sign committee discussion. At our last meeting, we decided in order to examine and modify the sign ordinance, we should formulate a committee. It was also decided that before we scheduled that meeting, we should get together with staff and put together a package with the suggested outline. Once again, whether it's a sign committee or just an advisory committee that's going to, on behalf of the planning board, either way, it falls under the right to know law. This is not a, I mean, think about it if that's not true. If a committee, if the planning board, or let's say the budget committee, can tell people to get together and then bring everything back, and the committee as a whole can tell them that, everything, literally everything could be done out of the public view using this loophole. And in fact, I had Donna make a note while Joanne was talking, because if they've been doing that with zoning ordinance changes every year, we need to talk about that. I think it was illegal every year. She thinks that's a reason to keep doing it. I think it's been illegal right along if they've sat down with Dick Marshall at the behest of the planning board to come up with zoning changes. Now, if it's, and I do need to make that clear. There is a difference. There is a difference between, as Councilor Orr suggested, planning board members drifting in and talking to staff. No problem with that at all. That's not what's at issue here. What's at issue here is that those group of people were assigned by the planning board to go off and do this work. That's the difference. That's the difference, and it's a huge difference. Now, I think the other thing could be considered an ethical problem. For instance, under the ICMA Code of Ethics, I'm not supposed to sit down individually and work with counselors on a proposal if the idea is to sort of circumvent the rest of the council, right? Joanne told me, Leo told me, in a minute Dick Marshall's going to tell me that they were assigned by the planning board to do this work by consensus. And that's what we're going to see at this meeting. So we have that. We added in those middle 3 lines, we added to the left and left with the idea that we would hold a meeting on September 23rd. So who would hold a meeting on September 23rd? Who was going to, after the last meeting, we're saying after the meeting on the 19th, that they were going to hold a meeting, that we left out with the idea that we were going to hold a meeting on the 23rd. So who held a meeting on the 23rd? The sign committee. Now they can pretend it wasn't a sign committee because my thing came out on the 20th and all of a sudden it became a non-sign committee, but it was posted as a sign committee meeting. And I will ask you to, well, we'll get to that in a minute. Let's finish here. Blah, blah, blah. Yeah, I did tell them not to do any more work on it. Page 70. Once again, Dick Marshall said, in the middle there with the lines, that was not part of the public committee. So I'm not sure if that means they thought that a non-public committee. It was so they have something consolidated in front of them when they walk in. And once again, if staff would have done this, perfectly fine. You know, that is actually what you guys pay us for, is going off, bringing stuff to you that, as Joanne talked about, the right to know law is very clear that staff work product, and still it gets to the board, is not public. But if you mix in anybody other than staff, you no longer have that exemption. Staff is allowed to do work because we put together stuff. We really have no decision-making authority at all. We're not assigned, we're assigned to do it as our staff function. But there's no political part of it, there's no issue. As she pointed out, staff is allowed to do that. The problem is that Mr. Marshall or any other member of the planning board or any other board or committee is not staff. So that exemption does not count in this particular case. And then I tried to say, really, did you guys really do that? The planning board, right under Dick Marshall, where he said, then what the planning board instructed us to do is what the problem was, telling me that the planning board did instruct them to do something, right? I said, well, I looked at the minutes and didn't see a vote of the planning board. So he corrected me. No, it was a consensus. The planning board told us to do this, okay? So he verified for me at that point, even though I wasn't there trying to goad anybody into saying, look, this was an illegal meeting. I tried to say, look, you guys didn't take a vote. You sure that's really what you were doing? Yep, that's what we were doing. It was a consensus. And then another planning board member, Mr. Scarpetti, said, yes, you were supposed to get together. And instead of coming back to us, they were going to meet with the sign committee. Irrelevant where they're going back to. If they were doing it at the behest of the planning board, it was going to the sign committee, and what was going to the sign committee was ultimately going to come back to the planning board. Okay? But whether it's the committee, a subcommittee of the planning board, a subcommittee of the sign committee, a subcommittee of a subcommittee, I mean, it's something, this was an advisory committee, a group of people sent out by the planning board to do work on their behalf and bring that work back. That's an advisory committee, in my opinion. I guess other people disagree with that. And then the bottom of page 71, they had this discussion, and it was like, well, maybe, maybe not, blah, blah, blah. I explained in the middle there that it's under definitions. I was concerned about this, so I called the municipal association and talked to their attorney, who suggested that RSA 91A1A definitions under 6D talks about advisory committees, subcommittees, subordinate body, etc. And then at the bottom, Representative Walsh, who was one of the members of the committee from the beginning, and I agree with Councilor Winnington. It appears some mistakes have been made. Maybe we're not clear when we put a charge to this committee, implying that somehow by consensus they put some kind of charge to the committee, but it just wasn't clear what it was. Maybe we should have put it to a motion, however, there was no malice. And then we agreed some kind of outline was necessary. He was surprised what they did, but basically he's saying, yeah, we set up a committee, we gave them a charge, the charge could have been clearer, but now let's straighten this out because we made mistakes. And then, page 72, this is not done yet, we're getting close though, we're running out of pages. Page 72, top, the third paragraph down, Joanne, J. Duffy. Could I ask for a motion that you hold a committee meeting of the sign committee on September 23rd? Now that wasn't asked for a motion to have a meeting. What you would normally do, by the way, and you guys all know this, I mean, we've done this, either you would just decide who you're going to appoint. I mean, you don't generally have pre-meetings of committees. Or you would suggest that a meeting be held that people could be invited to talk about it. And it would either be a meeting of the planning board or a meeting of the council or something like that. Because right now what we have, and just to jump ahead a little bit, the meeting of September 23rd, right, which is posted as a sign committee meeting and has minutes, who's going to approve those minutes? There was no sign committee. there's not even a majority of the people who were at the meeting that were appointed to the sign committee. So what was that? And that's why we've entered this alternate reality zone after the 20th. After I sent that letter, everything went strange. So she asked if they could have a sign committee meeting. When the consensus was taken under D. Rogers, the next one down, there were volunteers who agreed to serve on this committee, and there was going to be some reaching out to others. And once again, it was those names, right? You had a list of names that I've given you right along. It's the same committee. In case you forgot what they were, Joanne right below tells you who they were. My understanding that there was Dick, Tom Walsh, Leo, myself, Carolyn, here she added Matt, and 3 or 4 people from the Economic Development Committee. Basically the same people from beginning to end on this committee. No distinction between staff, planning board members, or anything else. It was a committee. And then, I forgot to mark it, but if you look down in the metallics and bolded below, D. Marshall moved that a committee meeting of the sign committee be held on September 23rd at 5:30 p.m. Seconded by Tom Walsh. Now, I can't prove this, but isn't it odd that the 2 people who moved and seconded it were also part of the original committee? I mean, it's not a coincidence. So the motion carried unanimously. There was no other committee formed or mentioned at that point. They talked about a pre-existing sign committee. And then Exhibit 16 on September 12th, I think it was September 12th, the sign committee agenda was posted. The business was going to talk about the establishment of committee. It couldn't have been, I think they tried to make the argument when they finally had the meeting after my letter on the 20th, that they were establishing the committee by showing up, but clearly that's not what they meant. What you do when you have new people on a committee like that, they were going to talk about why the committee was established, what they were supposed to be doing, what their charge was, but they clearly already had a committee in place that they were going to do that with. Because otherwise, you have, like I said, you have this weird situation where it's suggesting that they're creating themselves, and that was never the point. It was never what they were trying to do. It was the planning board establishing a sign committee. And that's what it was. Once the 20th hits, everything gets strange. All of a sudden, we go back, I changed colors here so I remember. All of a sudden, the sign committee minutes on the 23rd say we're supposed to establish a sign committee, which of course they couldn't do even if they wanted to. Don't know who was going to vote for these. As we've already seen, the 2 of the 3 committee meetings, the 8th and the 15th, had to be canceled because they weren't posted correctly. And then this is why I go back to the alternate reality. If you go to page 79, I don't know what happened, page 78. Page 79, in the middle, after Frank Kotowski moved to grant a motion to appoint the sign committee, seconded by T. Walsh, motion carried unanimously. Dick Marshall says, out of the blue, there was no sign committee until this action was taken by the planning board. P. Rogers, correct. There was no sign committee until it was just appointed now. And there has been no business conducted by this committee. Really? Really? I mean, once again, even if they think that's true, up until I sent that letter on the 20th, all I heard from everybody, from the staff members involved, the planning board members involved, that this was a committee assigned by the planning board to do this work. It was called a sign committee over and over again, on notices, on minutes, on everything, and all of a sudden, poof. certainly willing to answer anybody's questions on anything.
All right, thank you. So at this point, you will now be cross-examined by Ms. Douglas. Wanting to agree, proceed. Thank you.
It's getting late, so I promise I will be brief. Dr. Shankle, you said in your testimony just now, and please correct me if I'm wrong, that all it took for you was a call to the local government center to determine that what Joanne was doing was wrong. Am I stating your testimony correctly?
No. You need to be more specific. I said she was wrong about many things. What are you talking about specifically?
I believe you said all it took was a call to the local government center for me to determine that the meeting that she held on August 28th was wrong.
Oh, okay, on August 28th, I probably said that, yeah. That's true.
So in other words, you didn't know it was wrong.
I was double checking, because obviously if I'm going to be dealing with meetings like this, I want to make sure that I'm right. That's why I make calls. That's why we double check and triple check.
Should the council then impose upon you a training that would take place every workday, Monday to Friday morning, beginning at 8:15 and lasting until at least 9 in the town hall, which should comprise of, let's see, direct training, reading books, taking classes online, you're developing training for others, the best way for you to learn as you teach, working on special projects or anything else that they may deem as appropriate?
What, wait, no, I want to answer that question.
Excuse me. Chairman, excuse me.
I'm sorry.
Sorry.
I didn't hear you.
All right, I'm sorry, my mic was off. I've been advised that the question that you're asking is out of the scope of this hearing.
Would it be appropriate for you to be disciplined for your lack of knowledge?
No, no.
Excuse me, again, I think it's still in the same ballpark as the previous question.
You testified just now that the reason why you took the actions against Joanne was that you felt it was important that staff not appear to be working behind the scenes to craft an ordinance out of public view. That's taken directly from your first letter to Joanne, the undated letter. Is that why you disciplined Joanne? Because you felt it was important that staff not appear to be working behind the scenes to craft an ordinance out of public view?
I don't believe I said that was the only reason.
You did open the hearing today with the assertion that you were concerned that Joanne was tasked to work on the sign ordinance on behalf of individual planning board members.
No, I didn't. That's not true. I think you're incorrect. I'll put it that way. If you like, I can read it to you.
Read what, Dr. Shankle?
What you're trying to quote.
Your opening statement?
Yeah. Oh. No, that's not it. Let's see where I put it. Well, listen to me. That is, I believe then, and I believe now, that Joanne was part of a small group of people tasked by the planning board to work on the sign ordinance on their behalf. I further believe then and believe now that this group was therefore a public body as envisioned by RSA 91A, and I believe that as a department head for the town of Hooksett, she should have understood this and complied with the law. I think that's what you're trying to prove.
So you were truly concerned about Joanne working on behalf of individual planning board members?
No, that's not what I said at all. Tasked by the planning board. The planning board. Nothing to do with individual members.
The meeting with Joanne on September 9th, did you or did you not say Dick's not considered to be business friendly? Tom, business is already talking about a couple of sign meetings behind closed doors about without public inclusion. Dick not considered business friendly. Do you remember saying that during that meeting?
I really don't remember saying that during that meeting, but you know what? I may have said that because I do think that the business community has come to me and told me that they felt that Dick Marshall was a lot of the problem, especially when it came to signs. So I may have said that in the context of my job as being responsible for economic development, according to the people here, and the fact that the committee that was put together had somebody on it that I knew that the business community would have concerns with.
So you were actually concerned about promoting the interests of the business community?
It's one of my jobs.
You're not concerned about transparency and public participation?
Of course I am. You're trying, now you're just playing games. I told you. All these things. You're bringing up a conversation, I don't even remember it. I'm not even saying I said it.
Are you politically motivated, sir?
No, why would I be politically motivated? Politically motivated to do what? I don't even know what that question is.
To promote the interests of the business community.
No, these guys have given me direction to promote the interest of the business community. That's my job. From the very first time they interviewed me, they talked about economic development. Saying I shouldn't do that?
I'm saying that the purpose of the right to know law is to make sure that all aspects of the community, every aspect of the citizenry is represented. Do you disagree?
Why would I disagree with that? That's just a common sense statement that anybody would make.
Excuse me, I know these are not easy answers or easy questions, but can you please, we need to get to the facts, and it seems to be getting a little bit too argumentative for my liking. So if we could please, both parties please, ask the questions and please answer as quickly and as thorough as possible.
I'd like to just go through the chronology, beginning from when you learned of the August 28th meeting. Exhibit P97, you sent an email to Joe. P97. You sent an email to Joanne reading, "I was under the impression that the meeting the other morning was for staff and did not realize that a member of the planning board would be there. I am not sure that was appropriate, and it should be disclosed at your first meeting with the committee." Did I read that accurately?
Yeah.
Okay. And did you call the local government center after this email to determine whether or not it was or was not appropriate, the meeting?
at some point after, not right after this.
You continue.
Because, can I finish? I need to finish answering though, because at this point, I didn't know that the planning board had told them to meet. So I wouldn't have had any reason to think that there was a rights no violation at that point.
When did you tell Joanne what the local government center told you? When did you tell her conclusively that it was inappropriate?
I have no idea.
You never did you?
I don't know that. Why do you think that?
Joanne, after that email, did respond to you, right? She did respond to your concern about the potential for inappropriateness. Is that not true?
If you consider what's above there the response, yes.
And she wrote, the committee was formed as a subcommittee by the planning board. The board agreed to have an organizational meeting with Dick and Tom and staff. Although Tom did not attend, we did have a list of those waivers before we got started. The draft is just a starting point so we can move forward from there rather than spending hours discussing the same thing over and over. So she did explain to you what she was doing with that meeting. Is that not true?
She did.
Okay. Now, you said that in your testimony that you did try to talk to her about that, right?
I said, I did not specifically say that. I can't remember. I said that there were several times through this process that I stopped up there and she wasn't there.
Could you not have sent an email?
I could have done a lot of things. I didn't. I chose, and once again, my staff can tell you, I spent a lot of time walking around. I like doing things one-on-one, especially if there seems to be some confusion and misunderstanding. She made the point earlier that email isn't the best way to communicate that.
But if it was really important to you, wouldn't you have made sure that you emailed the local government center's response?
I don't know when I got the local, you're trying to say that I had it at that point. I don't know when I got the local government center's response. Because I didn't know there was going to be another meeting. I didn't have any reason to think that this was urgent. I have other things that I'm doing. I can't spend all my time on this.
Are you attempting to discipline Joanne for something that you yourself did not understand?
No.
After you walked in on the second meeting, the September 4th meeting, you wrote Joanne, I'm looking at P100. I told both of you that I thought it was inappropriate. Neither one of you are to do anything more on this, nor are you to provide any further staff support to the sign committee until and unless I give you written permission to do so. When are each of you free tomorrow? Did I read that correctly?
I don't know what, you didn't tell me what page you were on, so I don't know.
P100.
Yeah, I think so.
And did Joanne respond to you? Did she try to explain herself?
I don't know, did she? Can you tell me where she did that? Her email at the bottom there was prior to mine. The older email's first at the bottom. Hers was at 1:19 p.m., mine was at 1:44 p.m., so I don't see a response from her.
Okay, so that response is instead to the email that you sent on P99. I'm hoping that the meeting I just walked in on was not another meeting regarding the sign ordinance when I have expressed to both of you that I did not think it was appropriate to have meetings that did not include only staff. Did she respond to this?
You're back to page 99?
Yes.
You're asking me about an email I sent September 4th at 10:40. So I'm looking for something from her after September 4th at 10:40.
100.
So, okay, so that's the one at the bottom of page 100 where she said it at 119. Okay, I guess that's a response to that. Yes, it was. And that's where she explained to me again that it was really a committee set up by the planning board.
And after she explained herself, you sent a letter to her, correct?
Apparently so.
And in that letter, you primarily were concerned about her insubordination. Is that right? This therefore would seem to be an act.
I wouldn't say primarily. I mean, if primary, if you start at the top and presume that the first things you read are the most important. There was an introductory paragraph, then I talked about it was important not to be working behind the scenes to craft an ordinance out of public view, which is a right to know law violation. So I'm not sure why you think the other thing is primarily important, but it was an issue.
You talked about dismissal in terms of her insubordination, not in terms of violation of the right to know law. Is that a fair statement?
That is a fair statement.
And you required that she explain to you how she was not insubordinate, right?
I asked what?
You required that she explain to you how she was not insubordinate.
Okay.
And she wrote a letter back to you on September 6th saying, this is P106, I am writing in response to your request that I explain why I met with the planning board member regarding the sign ordinance on September 4th, 2013. Please know that I did not intend to disobey your orders with regard to that meeting. I genuinely did not understand that you had prohibited my meeting with the planning board member. From my perspective, I received an email from you on August 29, 2013 that stated that you were not sure if my meeting was a planning board member would be appropriate. I responded to this email explaining that the planning board itself suggested the meeting and the attendees. When I did not receive a response from you, I presumed you had no objection to my going forward as the planning board suggested with the planning board's participation. Apparently, I made an erroneous presumption, and I apologize for this. But this was in no way an intentional act of insubordination on my part. I understand that you are my supervisor and I must follow your direction, and I have every intention of doing so in the future.
I didn't hear a question.
Question, sir, is how does what flaw is represented by that response in Joanne as an employee that will be corrected by a training that takes place every Monday to Friday, every Monday through Friday from 8:15 to 9 o'clock at Town Hall or any other location that you decide, that could include working on special projects or anything else that you deem appropriate. What is the flaw that disciplinary action corrects?
From that one particular letter, or from the situation as a whole?
Why do you feel that disciplinary action corrects or remedies Joanne's insubordination in light of that letter?
That's like apples and oranges. My letter from the 20th had nothing to do with what she said there specifically. You have to look at my letter at the 20th to see how I put together I mean, just looking at that one letter makes no sense. I don't understand what
From
you're
the
getting at.
apologetic tone of that letter and from the explanation about the misunderstanding, do you think that a program lasting a year and threatening discharge should she be late once, having no discernible topical content, is appropriate?
Okay, so that's what you're asking me about now you're asking me about the appropriateness of the discipline. First, you made an incorrect statement twice, and I need to correct it, and that is, a couple times you said that I said that she would be fired for missing it once. That's not what I said. What I said was, being late for, and this is at the bottom of my letter of the 20th, which you have in your original packet, so we didn't save some paper and then repeat it. Being late for or failing to attend any of these training sessions will result in further discipline, up to and including dismissal. But it doesn't say that the first time she misses something 5 minutes late, she's going to be dismissed, and you've said that twice. So that's just not accurate. If you go through my letter, and I talked about a little bit in my opening statement, the letter talks about a number of management issues, it talks about ethical issues, it talks about legal issues. And I'll go back to what I said at the beginning. We're talking about approximately the same amount of time that somebody would put in with a 1 semester, 3-hour course in management. I've taught lots of them. You started asking me earlier what my qualifications are to do training. I've taught lots of those courses. I've taught them here.
And yet you had to call the local government center?
I've taught. You're going to interrupt me? I'm talking. I've taught in Ukraine. I've taught in Moldova. I've taught courses on organizational leadership and change management. And I still know enough that if I'm not absolutely sure about the law, I'm smart enough to still call. Why would I guess if I didn't know? Makes no sense. It's amateur stuff.
I have no further questions.
Okay, thank you. At this point, the town's legal, excuse me. Now the town administrator's legal counsel could do a cross redirect if they like.
I have no questions.
Okay. So at this point, it's now opportunity for the council to ask questions, and I believe we have some. Councilor Gomai.
Thank you. I just have one clarification here. Just a clarification. What are Joanne's hours?
Well, we've actually been looking into that. What the personnel policy says, that people are supposed to be here, or that the office hours are 8 to 4:30. One of the things we learned, in the general sense, Donna learned at a training she went to last week, this issue came up with salaried employees who drift in whenever they want and leave whenever they want. And what was recommended at a training that she went to, and she's already started looking into it, is that the only way to deal with that is to actually put the hours of work in people's individual job descriptions. We haven't done that here yet. You'll probably be seeing something like it in the near future. But at this point, we expect. I was attending. One was canceled this week because once again it wasn't posted properly.
Right.
Yeah, I can't say yes to that, but I try to attend all of them. I was there at that one. I was there at the one meeting, and I try to get to as many of them as I can. But one of the things that's happened with them actually in the last year or so is that they started moving around when they were doing it, because they were trying to find a time when the people could come. For a while, I believe we were doing it when they first started, when I first got here. I think they were doing them in the morning, and then they moved them to late afternoon, and it just depends on other meetings and stuff. I do a lot of other stuff, but I certainly do try to get there, because I know it's one of my responsibilities.
And then just one thing to be clear too, it's on page 13, I believe, in our attorney's thing, it says that, they're volunteering, like the staff can actually volunteer. That isn't really true, the staff is being paid to make those meetings. It's probably just a...
Okay, and you know that since I've been here, it's one of the things I've been working on. I got me and Leo off of the planning board because I don't think that's the right way to do it. And little by little, we need to get it through the minds of the people. You know, and this isn't just Hooksett, actually. When I was in Merrimack, we finally set a policy that staff couldn't sit on committees. Because what happens when staff sits on committees is that the real volunteers expect that the staff are going to be doing all the work. So committees assign work to staff, and that shouldn't be happening. I mean, that's not the way this is supposed to work. So it's another one of those things that that we're working on, but I did it first, to be the example. I got us off the planning board, and now I need to start working with staff to, do that.
All right, so of course, obviously, they were getting paid. Right. Okay, thank you.
Mr. Chairman,
Yes.
I do have a piece of information that would be helpful to answer Councilor Comey's inquiry. In the exhibit submitted by Attorney Douglas at P50, P40, there's a copy of Joanne Duffy's job description. And there was actually a statement about her hours on the last page of P42. So I just point out that this was an exhibit that Ms. Duffy offered. And it does say the hours are from 8 a.m. to 4:30.
Okay, thank you. Anything else? Councilor Orr?
I actually have several questions, if that's okay. I'm trying to. You're obviously you believe very strongly that the process that was followed was illegal. And early on, you suspected that it was illegal. And I guess my question is, as the person responsible for running the town's offices and responsible for the staff, do you feel that you did everything in your power at that time to prevent, to identify what you suspected to be an illegal meeting, and to prevent anything further from happening?
Well, like I said, I don't know that I will admit that I should have seen earlier that it was illegal, but the stuff that you're seeing now, I guess one of the things I'm saying, because if you look at things like the minutes of the HEDC meeting, I mean, I didn't see those then. I mean, a lot of the things are much clearer to me now, and when they really got clear was between their meeting on September 9th and when I finished my letter on the 20th, because I was gathering, and Donna and I were gathering all the information we could so I wouldn't make a bad decision. And so I didn't know, like I said the first time when I said it may have been inappropriate, I didn't know they'd appointed them at that point. I didn't really realize that till later. She said it, and I guess I should have clicked in, but the thing is, the right to know law, one of the things that I watched, there's shows on the Discovery Channel, History Channel, some of those things, and they're always doing these things where they show examples of people seeing what they think should be there as opposed to what really is. And I just didn't pick up on it quickly enough until I really sat down, really after the meeting on the 9th, when I said, I mean, that's why I said to them, well, did you guys really do this? I mean, I wasn't even sure at that point whether the planning board thought they had set up a committee. And that's when Dick Marshall said, yeah, we did it by consensus. And that's really when everything started to click. If I would have known it before that, certainly I would have jumped in. But I also didn't know, and like I said, I really was surprised that they had a second meeting after I told both of them the first one was inappropriate. Or maybe inappropriate. I mean, I don't know why they would have had a second meeting without having a sit down with me. If they didn't agree with me, they should have come to me and asked me why I thought that. And that's what I would have expected. And I'm pretty accessible around here, people can tell you. So I understand what you're saying, and I wish I would have caught it sooner, but I can't always, well, I just didn't. No excuse.
And then, as a follow-up to that, and again, I'm just trying to understand, because there's an expectation being set for department head to know something that she believed that she knew, and as it turned out, may not have known. So in that second meeting, you said you walked in, you saw them in there, you suspected that it might have been a second meeting, you went back down to your office and wrote that email.
Excuse me for just a second. I didn't say it in that order. I did not suspect there was a second meeting when I was upstairs. It did not occur to me that I went downstairs and sat down, but it might have been a second meeting.
Okay, I apologize, then it was that order. So when you went back down to your office and you thought, wow, that might be another second meeting, knowing how important it is to not have an illegal meeting, and you're in that building and you suspect that it might be, did you ever rethink your decision to not go back up? And I'm not saying to go in and say, this is an illegal meeting, but to kind of go in there, pull Joanne out, and say, you know what, I really think this might be illegal, we need to talk about it, and to stop it in the process so that it didn't continue, instead of just kind of wondering.
Well, like I said, at that point, I really wasn't even wondering, though. I mean, I knew that I didn't think they should be having the meeting, but in terms of it, I don't know if I really clicked in at that point that they had been appointed by the board. Now, I know she told me in that email, and I guess I just didn't pay close enough attention. But, I mean, anybody here, I mean, I think most of the staff will tell you if I think something's wrong, they usually know it. This thing, I could have done a better job with this, but she's a 20-year employee. She runs boards and committees all the time. I just didn't focus on it enough. Absolutely my fault for that.
Can I have another follow-up?
Yes?
And that brings up another question for me regarding semantics, I guess, or process. Someone can come to this council or any board and say, I would like to volunteer for a position. When new councilors come and say, we'd like to run for this office, where we're putting our hat in the ring to be in that position. From that up until, at that point, they're still just volunteers who would agree to take that position. Is it not true that until someone is officially appointed by the board that they are volunteering for, that they're not really technically board members?
Except that, even you folks do things by consensus on occasionally, or just tell somebody, sure, you can do that. It's not, and that's why I tried to tell the planning board, no, you didn't do this, and Dick Marshall corrected me and said, yes, we did do it by consensus.
When you say do this, what do you mean?
Well, form the committee. I mean, on that September 9th meeting, he argued with me about whether they had, and then they talked about the charge for the committee that they had.
And what's the difference between forming a committee and then appointing members to that committee? Is it one step or is it two steps?
Well, in this particular case, the September 9th meeting, which is somewhere. The question, I believe, September 9th.
I mean, you see my point, I'm trying to determine, because the big question here is, was it an official committee that was holding a meeting outside of the public realm? So I'm trying to break it down. So when do we determine when it is an official committee and when we appoint members to that committee and the process that goes in? And was that gray in this case, or was it clear?
Well, that's why I went through though. From the very beginning, Joanne laid out a number of people who volunteered for that committee. Every meeting after that, those are the people they invited to the committee meetings, and they called them committee meetings they were inviting them to. If you go down on page 70, I mean, you're going to have to read this yourself. It's a little,
I'm sorry,
page 70 of mine. I mean, that's where Dick Marshall says it's a consensus, and what he's talking about is what the planning board instructed them to do. So that meant there was a them to give instruction.
And then your response to that was that I think there is an ethical issue, even if there is not a legal issue.
That's right, and because when we were talking, that was talking about individuals sitting down without the consensus, because as you'll look, he then says the planning board instructed us to do is a problem. I said, I looked through the minutes, didn't see a vote of the planning board, so really, did you have this committee? Did you have instruction? And he said, yeah, we had a consensus.
A consensus to form the committee?
That's right, and to give those instructions.
Right.
That's what he was telling me.
Right, and at that point, and I'm finding my notes here, that it looks to me like on the meeting of October 7th was when officially members were appointed to this committee that was being discussed prior.
Well, that's where the alternate reality after my letter went out.
But I also don't see any minutes that say that there's been an official appointment of anybody to that committee. Is that, am I missing it?
Are you missing what?
Well, up until October 7th, there was no mention in any notes or meetings or letters or emails that people have been officially appointed.
Well, except that these same people from the beginning kept coming to meetings that were called committee meetings.
So it's kind of a vague, is it a meeting, is it a committee, is it not a committee, who's on it, are these official people on the committee, are they just people?
Well, like I
Right,
said,
that's September 9th.
all I knew is what I
But they're
had.
not appointed.
Okay.
I'm trying to use the public documents, I'm sorry.
Time out. I was getting instructed, the key is to ask him direct questions,
Okay.
if possible.
I thought I was, I'm sorry, I apologize. Who did
And I thought I was answering.
You were.
Okay.
I was happy. I don't know what happened. What did I do wrong? Okay, never mind.
We're just,
Okay.
Mr. Chairman, can we just have a moment to meet in non-meeting as a council? Can we have consultation with council, please, with the board as consultation with council as a non-meeting? Mr. Chairman, I request that.
I need to find out. Well, we're able to do that. If you want to go into a consultation meeting with legal counsel, we can. Well, the other, we can do a brief recess. And then we can, we'll ask everyone to leave, and then we can go into legal consultation if we need to for a few minutes. If that's up, that the board will need to ask if we want to recess at this point and come back in 5 minutes.
James?
Yes.
Question on the point of order. Do we need to have any kind of a vote to extend this meeting time beyond the traditional time that will be approaching shortly?
At 9:30, we can do that, yes. Okay, so there's a request to go to recess and go into consultation with our legal counsel. Is there a second?
Break.
A break.
Cannot recess, but a break.
Break. But while we're breaking, we're gonna have a consultation with our legal counsel.
I'll second it.
Okay? Moved and seconded. All those in favor are going into a break for 5 minutes. While we're in break, we're going into an official consultation with our lawyer. So I'll ask everyone to leave who's not privy, and we should be back within 5 minutes. Okay? All those in favor, say aye. Aye. Okay.
We're on top of the third.
Oh, okay, thank you for that brief recess. I'm just going to wait until all parties are here, and then we'll proceed. Council, would be appropriate for us to proceed with the questions in light of the fact that two councils are not here. If you don't have a problem with it, I'll ask Council Order to continue with the questions of the witness. If that was, I was trying to get that, you didn't ask. Okay.
Are you waiting for my response?
No, I'm just waiting for I'm waiting for two councilors. I was asking this council. And they'll
talk about the sander.
Okay.
Never go anywhere without my bodyguard.
Yeah.
Jim's your bodyguard? Yes. Okay. All right, so as you said, we're back from the recess. We're going to proceed with Council Orr's questions of the witness.
Thank you. I actually only have one or two more. Thank you.
Okay.
Let me find it again. Sorry, page 33. That is the letter that you wrote to. It says to Joanne Duffy, but it says that you both could understand. So I'm assuming you sent that same letter to both Joanne and to Leo. What was the date of that? This is a date. Mine's not dated. Do you know what the date of that was?
Yeah, September, I'm going to say 5th. Oh yeah, because on page 38, Leo says that this letter is a response to your letter of September 5th. So that's September 5th. Yeah, that's what I mean.
Now, in that memo, you said, it's my understanding that you both clearly understood, and you also said whether or not is obvious to you, my opposition to participation was apparently clear. So you used clearly understood. Did you have any conversations with them to clarify your understanding of what was going on? Is there anything spoken in between that time?
I definitely, I sent the email to Joanne, which apparently could have been stronger, could have been worded more strongly. I did talk to Leo because he stopped in my office, maybe right after the meeting. And I talked to him, even after the meeting on the prior meeting. But I did talk to Leo, and he certainly clearly understood.
Could you see that maybe it wasn't made as clear to Joanne as it could have been at that time, prior to this letter that you sent to her?
I won't deny that. However, it's sort of in the stream, it was irrelevant because the letter of September 5th wasn't the disciplinary letter. All I was doing at that point was still trying to gather information. She sent me back a letter saying, I didn't clearly understand it, and that actually informed my decision to give her a choice rather than, that's why I said in the letter on the 20th, you know, you said that, yeah, that's the way we've done it around here. We're not gonna, basically, don't do it that way anymore, and instead of any sort of dismissal, we'll do training, to train you in the way I want stuff done. So I did understand that I could have been clearer, and otherwise I would have taken other action. But I factored all that in, that's why it took me a few weeks before I sent the letter on the 20th, because I was still gathering information, still gathering my thoughts, wanted to make sure that I didn't do something that wasn't appropriate. So I factored that into the final disciplinary action.
I just have one last question, if I could. Had there been any other previous disciplinary problems with Joanne prior to this incident?
I'm going to ask you not to answer that because it's beyond the scope of this. You need to deal with this particular incident. Any incidents beforehand are not germane. That based on legal counsel.
Could I ask a question then, Counselor? Could I ask a question?
Private, yes.
Okay, I have no more questions, thank you.
Okay, thank you. Mr. Newham, any questions?
Well, just one question, because I was just curious on your letter on
Microphone?
that you mailed her, I think it. Really? Well, you don't, I can talk right in. On the letter, I think it was dated the 9th, right? That's the letter where you informed her that you didn't want to go to, or no, that maybe it is a letter of the 20th. You said that to her, that you asked her about being on your staff, and you mentioned that you don't feel that she answered that accordingly, or at least in her letter, there wasn't anything on there that, she had directly answered in her letter. Do you feel she did?
So you're asking me if I feel she responded to that September 5th letter?
No, the September 20th letter.
No, it was a September 5th letter, which is...
Yeah, but I meant the 20th.
Well...
Well, no, you're
The only answer-
right, you're right, the September 5th letter, because that's when you're asking her
Right,
why
the
you want to
only,
be on
the only
staff.
answer I got to the September 20th letter
Right.
was this hearing. Well, what I specifically asked, I'd like it, I said, before I decide on the specific level of discipline, I'd like to give you a chance to tell me why you chose to act as you did. I would think that this would involve discussing the town charter, the administrative code, and what you see as your role as part of my administration.
And that's the part, did she answer it?
I would have expected a more in-depth answer. I was expecting something, I mean, even just in terms of the difference between the two, and Leo's letter was a page and a half, and hers was 2 paragraphs.
Great, thank you.
All right, thank you. Mr. Jennings? Okay, Mr. Lazar?
Mr. Chair, I have several questions.
Okay.
Thank you, sir. Dr. Shankle, looking at I guess, in your booklet, the Buckley's booklet there, on page 4, which was the letter that was sent to the town council, or was motioned by the town council unanimously to take care of situations that we believed at that time was dealing with 91A. Could you explain why you highlighted these specific sections where on page 5 you said below the relevant parts, not all?
Well, I mean, let's just start on page 4 and then go to page 5, or just page 5?
On page 5, just...
Well, once again, as we went through this, there were two possibilities depending on how you look at what they wanted to do and what they did, and both of them were a problem. At the bottom, 91A1A 6D, it says those are definitions of a public body. It says public body under 6 says means any of the following. And then there's a whole list of things which include any committee, subcommittee, or subordinate body thereof, or advisory committee thereto. Up top, 91A1A1, or numeral 1, advisory committee means any committee, council, commission, or the like body whose primary purpose is to consider an issue or issue designated by the appointing authority so as to provide such authority with advice or recommendations concerning the formulation of any public policy or legislation that may be promoted, modified, or opposed by such authority. So those are that's sort of the theory of why they are not, why they didn't comply with direct no law.
So, follow-up question, Chair. So you had indicated that you had to start pulling together this information up to the 20th of September. In your opinion, did the committee, based on the information that you gathered, based on the comments, based on the minutes, did that committee, or did that meeting that occurred, do you believe it was an advisory committee?
Yes, I do.
Thank you. One more, Chair.
Proceed.
On the September 20th letter, September 20th, 2013, notice of disciplinary action, could you summarize what you've titled background and specifications for reasons for discipline?
Summarize it?
Yes. Summarize why you laid it out the way you did.
Well, I mean, that section goes all the way to the middle of the next page. You want a summary of all that, or what part of it you want a summary of?
Whatever you feel is most pertinent.
Well, I mean, I think all of it's important in that one of the things that we're discussing here is whether the requirement for the training is related to the specific issue at hand. And I guess that's why I put these things in here, to make it clear why I thought it was important. I mean, at the beginning there, when I talked about, first I talked about why I said what I said. It's actually sort of a summary of what I gave you earlier, that, I didn't know there was going to be another meeting. I make the statement there, as your supervisor, if I suggest that something is inappropriate, I expect that before you do it again, you will at the least determine whether it's legal. I talk about the meeting on September 29th. And then I sort of summarized that she said the committee was formed as a subcommittee. She kept talking about it as a committee. And at the very bottom sentence, a good management practice to verify at the very least the legality of the meetings. The next paragraph at the top, this is another management issue. The third line down, as a supervisor, it's imperative that you provide proper guidance to your direct reports. 2 sentences later, my comment should have raised a red flag, which with proper follow-up would have led you to realize that what you were doing was illegal and saved your staff from also being involved in these meetings. The next paragraph, accountability, is important. Never took ownership, and you heard her say tonight that she still thinks that it's appropriate what she did. That was the last question that the attorney asked her. But once again, she's been here a long time. There's been a lot of town administrators here. There's been a lot of different councils. We all know that Hooksett's had a complicated history the last few years. So the idea of giving training, to me, to be honest, was a positive thing. I just finished 4 courses at Rutgers about performance management, over the last 2 years. I'm a lifelong learner. I don't see anything, it's hard for me to even sort of conceptualize that as punishment. I think that learning more stuff is a good thing, and that's why I thought it through, okay, a 1-credit course, how many hours would that be? Or a 3-credit course, 1 semester, how many hours would that be? And that's why I came up with what I did. I still think my decision was reasonable. I think that the disciplinary action was reasonable, and that's what I tried to summarize in here.
One final one. If I may, I just want to ask for a motion to extend the meeting for a half hour.
I'll second it.
Moved and seconded. All those in favor of extending the meeting for a half hour, say aye.
Aye.
Okay. Another question for you, and then we'll move over to Council Winterton.
It just was a point of clarity, Chair. Dr. Shankle, could you clarify? You had indicated in that, and I was taking notes at the time, but you were saying that on the first letter that was sent, that you got 2 responses from it. Did you say that? Could you? Did you say that Mr. Lessard came down to you at that first letter? Is that how I remember that, or?
No, Mr. Lessard came down. I saw him, and I don't know if he came down specifically to that. He tends to stop in my office a lot when he comes through. And I saw him after the first meeting, but before the second meeting.
But you.
And that's when I talked to him.
Okay, but was he responding to the letter that you said was inappropriate?
No, because that came out,
this one was on
that came out, the letter actually came out after the second meeting. You're talking about the email to Joanne?
Yeah, August 29th. Right.
What number are you on?
P97.
Oh, that's hers.
That was her. That's. It was the one that hers. It was that was yours. Or maybe I have the wrong.
The August 29th meeting was the August 29th email from me to Joanne. I did not send a similar email because I talked to him in person because he stopped in my office.
Okay. Thank you, sir.
Okay, thank you. Council Winterton.
Dr. Shankle, in your letter of September 22, Mrs. Duffy, you include, under appropriate disciplinary action, will result in further discipline up to and including dismissal. Is that common language that you use in disciplinary forums, or was this unique to Mrs. Duffy?
No, that's sort of what Duffy form is, because otherwise it'd be, it's common language.
Thank you. Okay, very good. Any other questions? Yes, Mr. Dewey.
One last question. You just mentioned how Leo pops in your office in the morning sometimes, and of course Joanne isn't always in the morning. And I know planning board meetings run late sometimes, so maybe she jogs their hours like that. But again, I was just curious, is there some other time, a once monthly staff meeting, or did she pop in your office from time to time? Do you have?
We have staff meetings. We have staff meetings the Tuesday, 8 days before a council meeting. We always have a staff meeting because what happens, the way your council meetings get set up, is that we collect stuff. Jim and I usually do an email and then a phone call now. Come up with a draft. That's by Monday, a week before, 10 days. And then on Tuesday morning, we have a staff meeting, and one of the things that we do, there's two main points of that, is that we go over the draft agenda, make sure people are doing their staff reports, see if there's anything we need to go on that we don't know about, people bring in staff reports there. And then we go around and let every department head talk about what they're doing, what other people might need to know. We've actually taken a running as people, friendlier and talk, they usually go from about 9 to 11 or so at this point. And it's usually every 2 weeks, but unless you guys like in November, you only have one council meeting, so we probably end up only having one staff meeting. But we usually do that, and I do meet, that is another time, because we're all here. If people want to talk to me afterward, that's always a good time to catch me.
So there's more opportunity than just in the morning?
Yeah, oh yeah, I mean, I'm around all the time, I'm in meetings, but if people really pop in and say, come see me, I'll do that. I walk around the lot, it's my only exercise.
No, it's not like you should always have to go to them either, that's the point either, so that's just goes, thank you.
Okay, thank you. Mr. Winton, last question, sir?
Dr. Shankle, was there ever, or has there ever been contemplated a management policy within the town of Hooksett where all emails are CC'd to a person's supervisor?
No. So that's a direct question. The answer, I don't think we ever talked about it as far as any no such policy.
Thank you.
Okay, so very good. With that, that concludes our questions for the administrator. Are there any other witnesses from the administrator's side?
The administrator had no further witnesses.
Okay, very good. With that, we'll proceed according to agreed agenda items. We'll now provide an opportunity for a less than 10-minute legal counsel final closing statement, and then town planner's legal counsel's final planning. So at this point, we have the town administrator's legal counsel making a final closing statement.
And again, Dr. Shankle is going to make a closing statement on behalf of the town administration.
If I may, before you proceed, there was a question that was posed to the chairman or on behalf of the council on consideration of the Marshall letter, the Marshall affidavit. So we're going to allow that into evidence, but we're going to assign it the appropriate weight it deserves in light of the fact that Mr. Marshall cannot attend. So, okay? So with that, now it's the less than 10 minutes, please, Dr. Shankle.
As we've seen, in January of this year, the council had the chair send out a letter to boards and committees, providing them with, quote, the most relevant part of RSA 91A so that, as he put it, they would not, quote, inadvertently violate this important statute, close quote. Joanne and the members of the planning board at that time, which included most of the current board, received copies. As the preamble to RSA 91A states, quote, openness in the conduct of public business is essential to a democratic society. The purpose of this chapter is to ensure both the greatest possible public access to the actions, discussions, and records of all public bodies and their accountability to the people, close quote. On August 19th, when the planning board, quote, by consensus, according to Dick Marshall, authorized a group of people, including both board members and staff, to meet in order to save time, they knew that in order to do that, the subcommittee would need to do work that the entire sign committee would otherwise be doing. Whether this group of people were supposed to be phase one of the sign committee, as Joanne apparently thought when she met with the Economic Development Advisory Committee, or a separate advisory group set up to gather information and ultimately feed it back to the planning board through the sign committee, is actually irrelevant. By all accounts, until the alternate reality kicked in on September 20th, they were doing their work on changes to the sign ordinance on behalf of the planning board. They redlined the entire ordinance line by line, outside of the public eye, in order to cut down the amount of discussion that would otherwise have taken place in a public forum. To repeat the mantra I started earlier, I believed then, and I believe now, that Joanne was part of a small group of people tasked by the planning board to work on the sign ordinance on their behalf. I further believe then and believe now that this group was therefore a public body as envisioned by RSA 91A, and I believe that as a department head for the town of Hooksett, she should have understood this and complied with the law. In addition to her participation in this group, Joanne carelessly included her new employees in these meetings without determining the legality of such, did not inform the planning board of the concerns of the town administrator or indicate that they should be concerned about 91A, failed to communicate her activities to the town administrator, even after being prompted to do so by a peer, repeatedly defended her actions by pointing at the actions of the planning board, and used poor judgment in her dealings with a fellow department head when in the presence of non-staff. I have taught many undergraduate and graduate level courses over the years on such topics as organizational leadership and change management, the policy process, state and local government, and to be honest, I am not sure that the equivalent of a one-semester, 3-credit course is really going to be enough time. But I do think that it will be a good start and supply the basic information needed to be a productive part of my administration. I certainly hope you support me. I think this will be a big step towards starting to reduce the number of complaints that we get regarding the Community Development Department and will help us begin to raise its standards to what the public expects.
All right, thank you. Ms. Douglas.
I would just like to object to the reference to complaints regarding the Community Development Department. I don't believe any of that came in testimony. And as such, it does not belong in closing argument.
Okay, I will,
So noted.
so noted, thank you.
The right to know law is complicated. The reason why this hearing has lasted as long as it has is because we have 3 attorneys in the room, and we've talked about consult with the local government center and the municipal association. There is certainly room for reasonable, intelligent people to disagree over the interpretation and application of the right to know law. Under RSA 91A, you are committing an illegal act when you hold a secret meeting with a quorum of a public body. Now, as Attorney Buckley pointed out earlier, an advisory committee can count as a quorum, can count as a public body. However, the group of Joanne, Leo, Carolyn, Dick, and Matt was not an advisory committee. An advisory committee, as defined by 91(1)(a), means any committee, council, commission, or other like body whose primary purpose is to consider an issue or issues designated by the appointing authority, so as to provide such authority with advice or recommendations concerning the formulation of any public body or legislation that may be promoted, modified, or opposed by such authority. The authority in this definition is the planning board. They are the appointing authority. Dick, Joanne, Leo, Carolyn, and Matt were all meeting to advise the subcommittee, not the appointing authority. I want to remind everybody that Joanne's job description requires her to be an advisor. It requires her to give technical assistance. That's and you can certainly, I don't want to waste your time by reading it. You can certainly refer back to the exhibit in my packet. Ultimately, your task tonight is to decide whether or not the discipline as proposed by Dr. Shankle is appropriate for what Joanne did. After all of the testimony we've heard tonight, we can come away with certainly the idea that there is much gray area surrounding 91A. Dr. Shankle himself admitted that when he sent that email to Joanne about complaining about that initial meeting, even he did not understand exactly how appropriate it was, that he had to call the local government center. He wasn't even sure when he called the local government center and when he understood the wrongness, the alleged wrongness, of Joanne's act. In light of that, is it appropriate to have Joanne perform an ambiguous training program every day, every single day, for a year? When there are certainly other things that Joanne could be attending to for the town. Thank you.
Thank you very much. At this point, I'm going to ask the council to make a motion to close the evidentiary hearing portion of the appeal.
So moved.
Moved by Todd, seconded by Mr. Levesque. Okay. All those in favor, say aye.
Aye.
Okay. Now, at this point, the council will need to schedule a public deliberative session, and according to charter, we need to schedule that within 30 days, for which the council will decide on whether we agree or not.
Mr. Chairman and members of the council, I do have a memorandum of law that I would like to deliver as part of our closing argument to the council.
If that's... We'll accept that and consider that as well.
I'd have to insist that I be afforded the same opportunity, as that was not part of our protocols.
Do you have something to offer to us at the moment?
I don't. Might I ask for 10 days to submit?
Counselor, a letter was provided to you that said the legal memorandum had to be submitted by the end of the hearing on October 23rd.
I'm sorry, I didn't read that provision. Attorney Tangi.
So with that clarification, thank you, Mr. Tanguay. According to the agreed policy and sending in things that you were supposed to as of yesterday, I'm going to ask that, I'm going to say we can't unfortunately accept that. Okay? So at this point, we need to schedule a public deliberative session within 30 days. I'd like to make a suggestion that we schedule it 3 weeks from tonight, which would be the November 13th, which again would be coincides with the council meeting. So with that, I'd like to make a motion that we schedule the public deliberative session on this matter at 5 o'clock. Council chambers on November 13th, 2013.
Second.
Okay? Any discussion? 5 o'clock.
What was it, November 13th?
Yeah. 13th, sorry. Okay? Any other discussion? All right, so at that point, all those in favor of that motion say aye.
Aye.
Opposed? Okay, so we'll have that public deliberative session at our 13th meeting on the 13th. Thank you very much for everyone coming. And we would want to make sure that the Mr. Marshall affidavit is included in the packet as well. And it, with that, we have some council, other council business to deal with.